Well, that's me. And you know that already. There's Danielle, longer bio, not surprisingly. Okay, so to begin, why are we here today? Okay, because someone made you come, right? Well, basically, under Florida law, Chapter 720, which governs homeowner associations, within 90 days after being elected or appointed to the board, a newly elected board member must complete the educational curriculum administered by an education provider approved by the Department of Business and Professional Regulation. In other words, someone like myself and Danielle. Okay. And that's the course that we're doing today. The certificate of completion that you're going to receive, as Jeff mentioned before, is valid for up to 4 years. Okay. A director must complete this education course. Again, it may change over the course of time. 4 years from now. So this 4-year course you have to take every 4 years if you serve on the board uninterrupted. If you go off the board and come back on, you also have to take the 4-hour course. So, or this longer course, actually it's a 3-hour course. The topics that we cover, among others, are financial literacy and transparency, record keeping, levying of fines, and notice and meeting requirements. A director who does not timely file the educational certificate is suspended from the board until he or she complies with this requirement. During that time, the board may temporarily fill the vacancy during the suspension until the person becomes certified. The association must maintain each director's educational certificate for inspection by members for 5 years after the director's election. So even if the director only stays on the board for a week or a month, the certificate must be maintained for 5 years. However, the failure to have that written education on file, the certificate on file, does not affect the validity of any action the board takes while that director is serving. In addition to taking the course when you initially get on the board, there's some continuing education requirements for the time period that you're on the board. Again, uninterrupted. So if you have an association that has fewer than 2,500 parcels or 2,500 lots, parcels is used in the statute. Most people refer to them as lots. Then you have to take 4 hours of the continuing education annually. However, we've received written notice from the DPPR that when you first go on the board, okay, and you take this course, for your first year, this counts toward that 4 years, that 4 hours, excuse me. A director of an association has 2,500 or more parcels, a very large association, they have to complete 8 hours of continuing education annually. Okay, we mentioned Chapter 720. Chapter 720 Florida statutes is the statute that governs homeowner associations. It's actually relatively new, going back to the 90s. It used to be there was no statute governing HOAs specifically. Then they amended Chapter 617 to include some stuff. Chapter 617 is the Not-for-Profit Corporation Act. And then they moved that to its own chapter, which is Chapter 720. Okay. HOAs, homeowner associations versus condos. And we mentioned that this is not a condominium certification course, but just quickly, some of the differences between an HOA and a condo. A condominium association or a condominium only exists because it's created pursuant to statute. And the Condominium Act is Chapter 718. An HOA, again, for many, many years had no statute and therefore was basically created under common law. The reason for that is in a condominium, when you own a unit, you're owning airspace for the most part, particularly with a high-rise condo. Whereas an HOA, it's the old-fashioned lot and the dirt and the home. So for an HOA, you didn't have to have a statute. For a condo, you needed a statute to enable or have a mechanism for actually owning airspace. And that's why for condominiums, you have to have an enabling statute like Chapter 718 here in Florida. Creature of common law, creature of statute, I mentioned that. In an HOA, the common areas, which generally consist of anything from roads, green space, clubhouse, rec facilities, other things, they're owned by the association. In a condominium, they're called common elements, and a common element is not owned by the association, but it's owned by all the owners and shares. But that's a difference there between, even though the properties may look the same in terms of a clubhouse as a clubhouse, but an HOA association owns it. Condo, it's actually owned by all the owners pursuant to their share of ownership. In an HOA, typically the board will decide matters regarding alterations and things like that, unless the documents provide otherwise. In a condo, material alterations to the common elements are governed through the statute, and you have to have a certain owner approval or the approval required by your declaration of condominium. Again, I don't want to talk too much about condos, but I will here and there today, this morning, point out differences between the two, just because sometimes I think people get confused about, which procedure applies or which statute applies. Okay, what version of Chapter 720 applies? This means that what version applies with respect to your association and what laws govern the operation of the association. So under contract law, basically contract law 101, the substantive law in effect at the time that the contract, in this case, your declaration of covenants, because it is a contract, is executed, that's incorporated into the contract as if it were actually written. So basically, if your association was created in 1990, it's the law in effect in 1990 that governs the association for the most part. In constitutional due process, that protects you from retroactive application of a law that adversely affects a vested right or imposes or creates a new obligation in connection with a previous transaction or new penalties. Basically, what this means is that under Florida Constitution, a new law that comes into effect cannot impair or adversely affect an existing valid contract. So if you have a contract that was in effect and it said you can do X, Y, and Z, and that was legal, and then later on the law changes and says X, Y, and Z is not legal, that law, for the most part, typically will not apply retroactively to impair that existing valid contract. Except, and here's the exception, there's something called Kaufman language. The reason it's called Kaufman language is because it's a case called Kaufman versus Scheer. It was a condominium case dealing with condominium rec leases. Long story short, what that statute basically held is if your declaration is subject to, let's say, Chapter 720 as amended from time to time, then that will incorporate future changes to the act and they will impact your association with substantive legal rights. A big thing that came out recently about that, your HOAs, was vehicles. I think Danielle might get into that, or possibly during her part of this presentation. But long story short, if your document or if your declaration is subject to Chapter 720 as amended from time to time, then those laws will apply retroactively, okay? That's our substantive laws. Generally, procedural laws, things like meeting notice requirements, quorum requirements, those do apply retroactively because they're procedural rather than substantive. So sometimes it's difficult to, figure out, quite frankly, what laws are procedural, what laws are substantive. It does take some analysis into that issue, but it's key for the whole Kaufman language application. You see Kaufman language, quite frankly, more often in condos than you do in HOAs, but you do have to check. As I mentioned before, procedural laws means the means and methods for the application and enforcement of existing duties and rights. Again, for the most part, procedurally for the operation with meeting notice requirements and things like that. Substantive prescribes legal duties and rights. And once those rights and duties are vested, the process prevents the legislation from retroactively abolishing them. So substantive rights generally deal with things that you can or can't do, as opposed to just the procedure of operating the association. That's a very simplistic way to mention it. But again, this is an overview course, and this topic can get complicated with this legal analysis. What about conflicts? I mentioned Chapter 617. Chapter 617 is the Florida Corporation Not-for-Profit Act. And almost every HOA that I've ever seen, and condo for that matter, is created as a not-for-profit or corporation, which is not-for-profit. By the way, not-for-profit doesn't mean tax-free or tax-exempt. It just means that you don't pay your owners any kind of dividend or anything like that. So it's a corporation, not for profit. But it does govern in areas where Chapter 720 perhaps does not address an issue, then one must look to Chapter 617. But in the event of a conflict between Chapter 720 and Chapter 617, Chapter 720 will control with respect to the operation of your association. What about conflicts with your own documents? Okay, you have documents, you have a declaration of covenants, conditions, and restrictions, or declaration of covenants, they're called by different names, the articles of incorporation, which create the corporation, and the bylaws. And the bylaws typically specify the process or the procedures that operate the association, things like the meeting notice requirements, how many board members there are, and things like that. Sometimes the word bylaws is thrown around loosely, but you got to remember the declaration of covenants is actually the document of highest importance, because in the conflict or the hierarchy, we have this little dabble-do-ya with an ad from 1950 whatever, Brill Cream. And so the hierarchy, as far as what document controls in the event of conflict, is your declaration of covenants and restrictions is the document of highest authority. Then it's the articles of incorporation. Then it's the bylaws, okay? And fourthly, which is not on the screen, it's the rules and regulations. So the rules and regulations, although obviously still important in terms of hierarchy, they're the caboose, they're the last one. And in the event of conflict, the other documents will control. Now, you might say, oh, this never happens. Actually, it does. Okay, I've seen conflicts more often than I care to remember. Sometimes between articles and bylaws, for example, regarding who is eligible to serve on a board. Sometimes the articles will say board members need not be members of the association, where the bylaws will say board members must be members of the association. So the developer lawyer or maybe some association lawyer made some amendments. In that case, the articles would control over the conflicting bylaw provision if there was a direct conflict. Okay, we're going to talk about membership meetings. When I say membership meetings, that means lot owner or unit owner meetings. So every year, an association is required to hold a meeting of its members annually, which is the annual meeting, at a time, date, and place that's specified or fixed in accordance with their bylaws. Some bylaws will specify a specific day or a specific, like the third Wednesday of January or something like that. So you have to look at your bylaws and your articles, but usually it's in the bylaws regarding the date and time and place of the annual meeting. The election of directors must be held at or in conjunction with the annual meeting of the membership, or as provided in the association's governing documents. Almost always, I would say 99.9% of the time, the election is going to be held in connection or in conjunction with the annual meeting. Now, in addition to annual meetings, you can call, or the association can call, special members meetings. Now, special member meetings basically is any meeting of the membership other than the annual meeting. Okay, so when do you have that? Well, under most bylaws, a special members meeting can be called by the board. Some bylaws provide they can be called by, let's say, the president, depends what the language says. Or it can be called through a petition of the owners. Now, generally speaking, the owners can petition to call a special meeting of the membership when 10% of the total voting interest petition for it, unless your documents have a different percentage interest. And I would say in this case, again, 99.9% of the time, the bylaws, because again, that's the document dealing with procedures, will have a process or a procedure or a provision regarding the percentage of owners that may call a special meeting of the membership. So you need to check the documents and not just rely on that 10% figure that you see or that you just heard. Agenda. Okay, agenda is basically, what's happening at this meeting and what are we going to do? For an annual meeting, unless your governing documents require otherwise, and again, I'm going to harp on this a lot this morning, but you really got to check these documents because, the documents, in essence, for most things will control if there's a conflict. But unless the governing documents require otherwise, the notice of an annual meeting does not need to have a description or purpose for which the annual meeting is called. But let me advise you, I would include an agenda anyway. Okay, even though it may not be mandated statutorily, may be mandated by your documents, and even if it's not, it's a good idea. I think it's good practice to have it. However, for a special members meeting, again, any meeting of the members other than the annual meeting, the notice of that meeting must include a description of the purpose or purposes for which a meeting is called, and the business conducted at a special meeting is limited to those purpose or purposes which are set forth in the notice of the meeting. The notice requirements. Okay. All notices for membership meetings, annual or special, must provide and include the date, time, and location of the meeting. If your bylaws are silent or do not provide for giving notice to the members of a member meeting, then you have to mail, deliver, or electronically transmit notice to all the owners not less than 14 days before the meeting. Okay. Evidence of compliance with that 14-day notice requirement must be made by affidavit by the person who is providing the notice on behalf of the association. And that affidavit, you must maintain it among the official records of the association. And we'll talk about official records in a little bit. And the notice must be mailed or delivered to the address identified as the owner's mailing address in the official records of the association. Or if an owner has consented in writing to receiving their notice electronically, then to that electronic transmission address, which is either an email or a facsimile number. Although these days, mostly email, but again, owners have to agree in writing to receive their notice by electronic transmission. The association, as we just mentioned a second ago, may provide notice of any meetings, membership meetings, by electronic transmission, again, email or fax, to any member who has consented in writing to receive notices by electronic transmission and have provided a fax number or an email address for that purpose. Those addresses, email and address and fax numbers provided by members to receive notice by electronic transmission must be removed from your association records when the member or if the member revokes their consent to receive notice in that manner. However, the association is not liable for an erroneous disclosure of an email or fax number, or email address or a fax number for receiving electronic transmission of notices. And the reason why you have to remove it, quite frankly, is because email addresses of owners and fax numbers, for that matter, they're privileged and they're not allowed to disclose them to other owners unless the owner has agreed in writing for that email address or fax number to be their official address for receiving notices. Electronic transmission may not be used as a method of giving notice for a meeting called in whole or in part to recall a director. So for a recall meeting, you cannot use the electronic transmission as a manner or as a method of providing notice of that meeting. In addition, other notice requirements, in addition to sending the notice to the owners, again, by mail, delivery, or electronic transmission, you may, by rule, reasonable rule, adopt the procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed-circuit cable television system which serves the association. The notice and agenda must be broadcast in a manner and for sufficient continuous length of time so as to allow an average reader to observe the notice and read and comprehend the entire content of the notice and the agenda. Also, websites. By January 1 of last year, okay, an association with 100 or more lots or parcels was required or is required to post the notice and agenda of each scheduled members meeting at least 14 days before the meeting. In other words, post it on the website. The notice must be posted in plain view on the home page of the website or the app, or on a separate subpage of that website or app labeled Notices, which is conspicuously visible and linked from the homepage. The association must also post on its website or the app, if you have an app, any document to be considered and voted on by the members during the members' meeting, or any document that's listed on the agenda, and you have to post that at least 7 days before the meeting at which the document or information within a document is going to be considered by the membership at that meeting to be voted on. What about participating in the meeting? Well, unsurprisingly, owners, members of the association, and that can be used interchangeably, have the right to attend all membership meetings and to speak at any meeting with reference to all items that are open for discussion and all items that are included on the agenda for the meeting. And notwithstanding anything to the contrary in your governing documents, an owner has a right to speak on any item, again, brought up for discussion or on the agenda, for at least 3 minutes. The association may adopt reasonable written rules governing the frequency, duration, and other manner of owner statements, which rules must be consistent with what I just mentioned. And I think it's a good idea to adopt those rules as a matter of fact. It just keeps order to your meeting. Membership meetings must be held at a location accessible to a physically handicapped person if it was requested by a physically handicapped person who has a right to attend the meeting. Also, owners may audio or video record membership meetings, and the board may adopt reasonable rules governing the recording of meetings. Again, reasonable, such that you can't move around the room. You can't, usually now it's done through your cell phone. In the old days, they would set up cameras and things with lights and everything else. But nowadays, it's usually by a cell phone. So again, you can have reasonable rules regarding the recording, but you cannot prevent an owner from recording audio and or video. Quorum. Okay, we're talking about membership meetings now. Okay, so unless a lesser number is provided in your bylaws, 30% of the total voting interests of the association constitute a quorum at a members' meeting. Now that's present in person or by proxy. We'll talk about that in a few minutes. So a lot of documents, particularly the older ones, and maybe even some current ones, will say that a quorum of the membership for an HOA membership meeting is a majority of the members. Well, that used to be the case, quite frankly, until again, the law was amended to provide that it's 30%. And if you think, well, isn't this a Kaufman issue? Well, there's no case law that I'm aware of it, but most practitioners that do what I do, that do what we do, have deemed this to be a procedural rather than a substantive statutory provision, and therefore it does apply retroactively and does apply to your existing documents. Again, so quorum for membership meeting, 30%, unless your documents have a lower number, like 20 or 10. Unless otherwise required by law or by your governing documents, decisions that require a vote of the members, i.e. owners, must be made by the concurrence of at least a majority of the total voting interest present in person by proxy at which a quorum has been obtained. So, in essence, a majority of a quorum. So what does this mean? This means really it's a sliding scale. It depends how many owners are represented at that meeting in person or by proxy, as long as it's a quorum, and then it's a majority of that to render a decision. However, crucially important, if the statute or if your documents require a different vote, usually a greater vote, then you have to comply with that. So if your declaration, for example, says it can't be amended without 2/3 approval of all the owners, then that controls, as opposed to, what we mentioned here, which is a majority of a quorum. And when it's a majority of a quorum, again, it's a sliding scale. The greater the attendance in person or by proxy, the greater vote that's needed, okay? The lesser attendance, the lesser vote that's needed, but at a minimum, you have to have a quorum in order to have a valid vote. Proxies, just mentioned that. Unless otherwise provided by the statute, which in this case is section 720.3068, or in the governing documents, members have a right to vote in person or by proxy. Again, check your bylaws. Occasionally, you'll see bylaws that prohibit proxy voting. It's somewhat unusual, but it is possible. So you have to check, particularly when you deal with board elections. And we're going to talk about that in a little bit. To be valid, and basically, what is a proxy? A proxy is when you're appointing another person to vote on your behalf, in essence, to vote for you at the meeting. So you're assigning someone your rights by granting them your proxy. Anyway. So to be valid, it must be dated. It must have the date, time, and place of the membership meeting for which it was provided and given. And it must be signed by an authorized person who executes the proxy. Under your bylaws, it'll say who's authorized to vote for units, including those lots that are owned by multiple persons or maybe owned by a corporation or something like that. So you have to check and see who is authorized to vote on behalf of the lot at a membership meeting. A proxy is effective only for the specific meeting for which it was originally given and any lawful adjournments of that meeting. However, proxy does expire 90 days after the meeting. Now, Because a proxy is valid for 90 days, then there's a mechanism you can use at a membership meeting to perhaps, garner more votes. For example, if you hold a membership meeting and you're voting on amendments to your documents, and although you might have a quorum there, you don't have enough votes to adopt the amendment, pass the amendment. Actually, and those proxies are good for 90 days, the meeting can be adjourned and not finally adjourned, but adjourned to be reconvened at a subsequent date with proper notice. And then those proxies are still good for that reconvened meeting. And in the meantime, you can go out and solicit more proxies or more people to come to the meeting when it's reconvened. So the fact that the proxy has a 90-day life from the date of the original meeting gives you some flexibility sometimes in doing that process to gather more votes if needed. Proxies are irrevocable at any time by the person who executed it. So if I give someone a proxy and then I change my mind, I'm going to revoke it. I can revoke it in writing, and then that proxy is no longer valid, given to that person. Any proxy holder may appoint, because most proxies have a substitution of power provision in it. So a proxy holder may appoint in writing a substitute proxy to act in his or her place. So if I grant my proxy to someone and that person for some reason can't attend the meeting, then through that substitution power, the proxy holder can then substitute someone else, to be my proxy. But the proxy usually has that power right on the face of the proxy as far as substitution. Now, do you have to have the original proxy there? No. Proxy can be a copy, and it's still valid as long as it's a complete reproduction of the original. In other words, signed, dated, with all the information that we mentioned before. So if it's a copy, that's still a valid proxy. It doesn't have to be the original proxy that you granted to someone. General versus limited proxies, and I will make a little distinction here with condos and HOAs. A general proxy allows a proxy holder to vote however he or she sees fit on any matter that may be undertaken at that meeting. So under a general proxy, if I grant, Joe Smith, Betty Lou, whoever, a general proxy for me, then at that meeting, my proxy holder, Joe Smith, whatever, he can vote, or Betty Lou, she can vote any way she wants on my behalf on any issues that come up before the meeting. A limited proxy, though, is one that on the face of the proxy specifies how my vote shall be cast. So in a limited proxy, let's say you're voting on an amendment, it will say right on the face of the proxy, vote to amend Article 15 of the Declaration regarding pets, yes or no. That will be checked off, yes or no, by me as the owner. When I give that proxy to the proxy holder, then he or she cannot use their discretion, cannot use their judgment. They're just basically there as a warm body, and the limited proxy is directing how my vote is cast. Now, in condominiums, I know this is not a condo class, but I'm going to mention it, you can only use limited proxies to vote on substantive issues. You can't use a general proxy. In an HOA, there is no such limitation unless your documents limit how proxies shall be used. So in an HOA, in the absence of the bylaws or the articles limiting how proxies are used, you can use or general or a limited proxy. So it depends. Both are good, though, to establish a quorum. Electronic voting. So electronic voting basically is online voting, an internet-based online voting system. A board can establish that the association can have electronic voting if they adopt a resolution at a board meeting. That board meeting must have 14 days notice, And again, the 14 days notice must be provided to the owners by mail, delivery, or electronic transmission, and posted in the property. So this type of notice is not just posted. For a meeting to adopt electronic voting, online electronic voting, you have to mail, deliver, or electronic transmit and post the notice of that board meeting at least 14 days in advance. That resolution that the board adopts must provide that owners or that members will receive notice of the opportunity to vote through an online voting system. It has to establish reasonable procedures and deadlines for members to opt in or opt out to online voting, to consent to it. As I mentioned, opt in or opt out. The association may conduct membership voting through the online voting system if a member consents electronically or in writing to online voting, which is valid until that owner opts out of online voting if he or she decides to opt out of online voting. And when you're voting electronically, that counts toward a quorum, okay? So for quorum purposes, in-person counts, by proxy counts, and a ballot or a vote cast online electronically also counts toward a quorum. If you have electronic voting, if your association adopts electronic voting, then each owner has to be provided with a method to authenticate their identity, a method that's consistent with your election process and your bylaws. We'll talk about that later. A method to confirm at least 14 days before the voting deadline that the owner's electronic device can successfully communicate with the online voting system. You have to use an online system that's able to authenticate the owner's identity, authenticate the validity of each electronic vote to ensure that the vote is not altered in transit, transmit a receipt to each owner who casts a vote online, and permanently separate any authentication or identifying information from the electronic election ballot. So it's impossible to link any ballot to any owner, okay, if your bylaws or if your documents require secret ballots for the election of directors. Some bylaws do for HOAs and some don't. And the system must be able to store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. Now, generally speaking, the companies that sell the software for electronic voting will comply with these things. So it's not like the association has to, create its own electronic voting software system. These systems are available for purchase from various companies. And generally or typically, they do comply with, obviously, with these requirements. Now, we said we're going to talk about elections, and we will. So this is governed by Chapter 720 and specifically 720.3069. All right. A vacancy on the board that's caused by the expiration of a director's term is filled by election. And I say expiration of a term as opposed to other reasons why that seat may become vacant. We'll talk about that in a little bit. The election, as I mentioned before, must be held in conjunction with the annual meeting or as otherwise provided by your documents. Elections must be conducted in accordance with the procedures set forth in the governing documents. And this third bullet point is crucial, okay? That you have to conduct your election pursuant to or in accordance with the procedures in your governing documents. Generally, those procedures are set forth in your bylaws. This is completely different from condominium associations. I'm going to mention it now because there's some confusion here. Condominium association election of directors is governed by statute. So condominium associations elect their directors pursuant to the procedures set forth in the Condominium Act and the Florida Administrative Code, which has rules that supplement the Condominium Act. But that's not the case for HOAs. The statute, Chapter 720, does not govern the election of directors. It has some things about it we're going to mention under certain circumstances, okay? But first and foremost, you have to do it in accordance with your documents, with your bylaws. Now, unless otherwise provided in your documents, okay, a quorum of the members must be established in order to conduct an election and any other business of the association at the annual meeting. There is one exception to a quorum requirement for a board election for an HOA, and we're going to mention that shortly. Unless otherwise provided by your documents, directors elected by a plurality of the votes cast by eligible members. And in other words, those people who get the most votes win the election. You don't have to get a majority of the votes of all the owners. It's a plurality, okay? Again, unless your documents have otherwise. Who's eligible to serve on the board, okay? All members are eligible. In other words, all members of the association are eligible to serve unless they've been disqualified. And we'll talk about some of the reasons that people can be disqualified, okay? But, okay, you might ask the question, can only owners serve on the board? That depends on your documents, okay? If your documents provide that non-owners or non-members can serve, then they can serve too. So you have to check your documents out to see whether they restrict board membership or, who's on the board to only owners or only members of the association. This is something, again, you have to check in your documents. Now, A person who is delinquent in the payment of any monetary obligation, so that can be an assessment, a fine, whatever, any monetary obligation to the association on the day that he or she could last nominate himself or herself or be nominated for the board, cannot seek election to the board, and his or her name cannot be listed on a ballot. So when's the last day that you can nominate yourself? Well, that depends. It depends on your documents. It depends whether or not you have nominations from the floor. It depends if you have a pre-nomination process. So again, this is something where your documents will control the nomination process to be on the board in conjunction with the statute. And we'll mention that shortly. So who else is ineligible? Well, a person who has been convicted of a felony in Florida or in a U.S. district or territorial court, or has been convicted of a felony in another state, some other jurisdiction, which would be considered a felony if committed in Florida. Those individuals are not eligible to serve on the board unless his or her civil rights has been restored for at least 5 years as of the date that he or she seeks election to the board. Also, another reason for being not eligible is if you have a pending criminal charge for forgery of a ballot, envelope, or voting certificate used in election, a felony theft or embezzlement of any association funds, okay, or property, tampering with physical evidence, which is the destruction or the refusal to allow timely inspection or copying of an official record in furtherance of a crime, and obstruction of justice. Okay, if anyone has just been charged with those things, don't have to be convicted. If you have arrested, indicted, formally charged with any of these items, then you're not eligible to serve on the board until those things have been dismissed. Nominations. Okay. This is going to depend upon your documents, but if your documents provide as such, a member may nominate himself or herself as a candidate for the board at a meeting where the election is to be held. Nominations from the floor. However, if the election process in your documents has a pre-nomination election procedure, pre-nomination process, then you're not required to have nominations at the meeting. I'm going to divert to the condo again for a second here, because again, there's sometimes people think one controls both, and it doesn't. In a condominium, there are no nominations for board members from the floor. They're not permitted. There is a statutory pre-nomination process where you have to place yourself into nomination or for nomination in advance of the meeting. Some HOA documents have that. They do. They've got procedures that are similar to a condo because that's how they were drafted. Some have been amended to include that, but many, many, many do not. Okay. And if they do not have a pre-nomination process, then nominations must be taken from the floor at the election, at the annual meeting. The election day, election by acclamation. Well, that basically means that an election is not required unless you have more candidates, more eligible candidates, than vacancies exist, okay? If an election is not required because there are either an equal or fewer number of candidates than vacancies, and if nominations from the floor are not required, in other words, if there's a pre-nomination process, so you don't have nominations from the floor, and you have the same or fewer number of candidates than you have vacancies, then those qualified candidates commence their service on the board, regardless of whether a quorum is attained. So this is the exception to having a quorum at the annual meeting for an election. To say that again, if you have a pre-nomination process and nominations on the floor are not required in that case, and you have the same or fewer number of candidates as vacancies, then there's no quorum requirement and those candidates are automatically elected. Balloting. The members have a right to vote in person or by proxy, again, unless otherwise provided in your documents. And you have to check. For those HOAs that have adopted in their bylaws a condominium-style election, and frequently it'll say that there is no proxy voting for directors. But unless your documents have that type of thing, where they preclude proxy voting, then proxy voting for directors is permitted. In condominiums, it is not permitted. You cannot vote for directors by proxy. In HOAs, you can, unless your documents say you do not have proxy voting for elections. Also, If your governing documents permit voting by secret absentee ballot, okay, and I'm going to make another diversion here. In condominiums, the only way to vote for directors is through a secret absentee ballot, all right, or through secret balloting. HOAs, not the case, again, unless it's in your documents. But if your bylaws have absentee secret balloting, then your ballot must be placed in an inner envelope with no markings other than it says ballot, okay? And then that must be placed in an outer envelope, and the outer envelope must identify the name of the owner, the lot or parcel for which that ballot is cast, and the owner or the member casting the ballot must sign that outer envelope, okay? Again, if you have secret absentee balloting in your bylaws for elections. All ballots and proxies are tabulated on the day of the annual meeting. If more than one ballot is cast for any lot, then those ballots for that lot are disqualified, and any ballot must be received after the closing of balloting is also disqualified, is not considered. All right. Finally, unless your bylaws provide otherwise, directors serve a one-year term. Now, some documents, actually many bylaws, will have directors serving multi-year terms in the staggered board. For example, they serve 2-year terms and they're staggered. So every other year you elect, let's say 3 or 2 or 3 or 4, depending on your board. But in the absence of anything, directors serve a one-year term, unless your bylaws provide for multi-year terms. What about challenging an election? Well, any challenge to an election must be brought within 60 days after the election results are announced. Okay, so there is a time limit, fairly short, on when an owner can challenge an election. If there is a challenge, or if there is a dispute, okay, between an owner and the association regarding an election, then that is submitted either to binding arbitration with a division. What's a division? That is a division of Florida condominiums, timeshares, and mobile homes. So that generally regulates condominium associations, but in this instance, the division also has jurisdiction with respect to HOA elections. So an election dispute can either be arbitrated through the division, or you can file it with a court of competent jurisdiction. Usually that will be circuit court in the county where your association is located. Election disputes that are submitted to binding arbitration with the division must be conducted in a manner provided in 718.1255 and the procedures adopted by the division. So again, that is we said before, there's no condominium here. Well, there is some, because in this instance, there is jurisdiction for election disputes, either in court or through the division as regulated under 718.1255 of the Condominium Act. Officers, we talked about election of directors. Now we're talking about election of officers. Generally, and again, this is like 99 point whatever percent, okay, the bylaws provide that the officers are appointed or elected by the board. Usually it's immediately following or shortly following the election of directors at the organizational meeting of the board. So president, vice president, secretary, treasurer, etc., the officers are elected by the board. Now, generally speaking, directors may not vote by proxy or by secret ballot at any board meeting, except there is an exception. They can vote by secret ballot when they're electing the officers. And there's no prohibition against changing officers midterm. So even though an officer, president, vice president, secretary, whoever, treasurer, they might be elected to a one-year term under most bylaws, again, that 99% there again, they serve at the pleasure, or maybe a better word is displeasure, of the board. So a board can change officers. Now, board members cannot remove other directors from the board, though, okay? Board member can only be recalled, okay, by a vote of the owners or a vote of the members. So the board cannot vote off a board member from the board. They can, unless the documents promote otherwise, change officers, though. That officer will still stay on the board, but he or she may no longer have that office that they previously held. Fraudulent election voting activities, and I'm sure this won't apply to anyone listening or watching, but just be aware, a person who engages in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. What are those things? Willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to or affirm an oath or affirmation in connection with or arising out of any voting activity. Perpetrating or attempting to perpetrate or aiding in the perpetration of fraud in connection with a vote cast or to be cast or attempted to be cast. Preventing a member from voting or preventing a member from voting as he or she intended by fraudulently changing or attempting to change a ballot envelope vote, or voting certificate of a member. And finally, menacing, threatening, or using bribery or any other corruption to attempt, directly or indirectly, to influence, deceive, or deter a member when the member is voting. Now, hopefully none of these activities will apply to anyone who is on this Zoom. It's just there was an association down in Miami-Dade had all sorts of shenanigans going along with their elections and other things. A lot of these laws, it wasn't just that one association, but so a lot of these laws arose out of that to try to address some shenanigans that were occurring out there. Other fraudulent voting activities: giving or promising directly or indirectly anything of value to another member with the intent to buy their vote. Well, can't be buying votes. Or another member to corruptly influence that member or another member in casting his or her vote. However, this doesn't apply to any food served, which is to be consumed at an election rally or meeting, or to any item nominal value which is used in election advertisement. In other words, so if you're running for the board and you give out campaign pins or campaign stickers, that's not buying votes, okay? If you have a campaign rally and you're serving, hot dogs and hamburgers, whatever, that's not in violation of this provision either. Finally, using or threatening to use directly or indirectly force, violence, or intimidation, or any tactic of coercion or intimidation to induce or compel a member to vote or refrain from voting in an election or on a particular ballot measure. Also, that's a fraudulent voting activity. No surprise there. Effective July 1 of 2024, these acts are also constitute a first-degree misdemeanor. Knowingly, again, knowingly, not inadvertently, knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, and having knowledge of a fraudulent voting activity and giving aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. Again, hopefully all these things are just for your knowledge and will never be actually needed. Vacancies on the board. Okay, we talked about vacancies that are filled at the expiration of a term, which is through the annual meeting and the election. However, unless your bylaws provide otherwise, any vacancy occurring before the expiration of a term, except by recall. So what does that mean? By death, by resignation, by disqualification. When I mean disqualification, if your documents require board members must be owners, and then someone is no longer an owner, well, then they're disqualified. So if anything happens to create a vacancy prior to the end of a term, okay, unless your bylaws prove otherwise, that vacancy may be filled by the affirmative vote of the majority of the remaining directors, even if less than a quorum, or even if it's just one director remaining on the board. In the alternative, the board can hold an election to fill the vacancy, in which case that election must be held in accordance with the bylaw provisions that we were just talking about. Generally speaking, though, in my experience, the board will fill those type of vacancies by appointment, again, unless their documents provide otherwise that they can't. Finally, unless otherwise provided in the bylaws, a person or a board member who is appointed to fill that type of vacancy serves for the unexpired term of the seat being filled. Now, occasionally you will see that where you have multi-year terms, the bylaws may say that in this kind of instance, where you're filling a vacancy because of death or resignation, that the person only serves until the next annual meeting. So that would be a difference from the general law, which is the person appointed to fill a vacancy before the end of a term for generally is appointed to serve the unexpired term, again, unless the bylaws provide otherwise. Board of directors. We talked a little bit about them, a little more, and we'll talk some more about directors and under 72303. Board voting. Okay, the officers and directors of an association have a fiduciary responsibility to the owners. By the way, fiduciary, you hear that term a lot. Fiduciary obligation, fiduciary responsibility. Basically, it means trust. That you're in a position of trust with yourself and the members of the association. Does that mean you always have to be right? No, but you must act reasonably. And there's something called the reasonable business judgment rule. What does that mean? That means as long as you're acting reasonably in good faith, okay, then your decisions, really, although the outcome may not be what you anticipated or, whatever, it's not really subject to challenge by owners saying that you've acted improperly or acted wrongly, as long as you're acting reasonably and in good faith. That's the reasonable business judgment rule, not meaning that you always have to be correct or right, whatever that means. Unless otherwise provided by the documents or by law, the association's powers are exercised by the board. So for most part, the board is running the corporation. The board is running the show without owner vote, except for those instances where by statute or by your documents, the owners must approve an action or something being done. Things, for example, like amending the documents usually is an owner vote. Not always, but usually is. Unless delegated, no one board member should be making decisions for the board. And, and this is actually important. I've seen many associations where one person, maybe a strong-willed person, or not so strong-willed, but everyone just defers. So the president, makes all decisions unilaterally. And that's not how it works, okay? The association is run by the board. The board acts as a group and decisions are made, by votes of the board, whether that's unanimous, whether it's split, however the vote turns out. But again, no one individual should be making unilateral decisions for the board for the association. As I mentioned before, directors cannot vote by proxy or by secret ballot, except secret balloting can be used in the election of officers. Now, you can attend and vote remotely at a board meeting, as long as through a Zoom or through a conference call, as long as everyone in the room can hear you and you can hear them, so you don't have to be there in person, but you can't just give someone a proxy and say, vote for me. Members of the board can use or may use email as a means of communication with each other, but you cannot vote on a matter by email, statutorily. All board meeting notices must indicate the date, time, and place of the meeting, and must specifically identify all agenda items for that meeting. If you're going to be considering an assessment, whether that's a budget or a special assessment, the notice of the meeting must include a statement that assessments will be considered and the nature of the assessments. I'm going to talk about special assessments in 1 second. Unless the bylaws provide otherwise, or unless the law requires otherwise, notice of all board meetings must be conspicuously posted in the community at least 48 hours before meeting, except in an emergency. By the way, that's a bona fide emergency, okay? Like hurricane or something terrible, something like that, emergency. An emergency is not, it's April 17th or whatever today is, and half the board's leaving up north tomorrow, okay? That's not an emergency. It has to be a bona fide emergency. Now, there are certain board meetings that require more than a 48-hour posted notice, okay? 14-day notice. So unless your bylaws provide otherwise, written notice of any meeting at which a special assessment or an amendment to the rules regarding the use of a lot will be considered, the notice for that board meeting must be sent to all the owners, either mail delivered or electronic transmitted, and conspicuously posted on the condominium property, on the community properties. I made the same mistake myself. On the property, in the property, at least 14 days before the meeting. Now, with special assessments, this is crucial, okay? If you're going to be adopting a special assessment for whatever purpose, okay, the notice of that meeting, for that special assessment meeting, must be posted, okay, and sent to all the owners at least 14 days in advance of the meeting. It's important that you do that, because if you don't, someone can, not pay that assessment and be successful in challenging it if the notice of the meeting at which it was adopted was not done properly. So you do have to be careful that you are doing that. And for that special assessment, include the purpose and the amount, estimated amount of the special assessment. Notice on your website. Okay, we mentioned before that if you have 100 or more lots, you're required to have a website. The association may adopt by rule, in addition to the other notice requirements or methods, a procedure for conspicuously posting the board meeting notice and the agenda on your website or an app, downloadable app, for at least the minimum period of time for which notice is also required to be physically posted in the community, which is either going to be 48 hours or 14 days, depending on the meeting. Any rule adopted must include a requirement that the association send electronic notice to members whose email addresses are included in the association's official records in the same manner as is required for notice of a meeting of the members. Such notice must include a hyperlink to the website or application on which the meeting notice is posted. As I mentioned before, by January 1 of last year, you're required to have a website, and you have to post notices of any board meeting and the agenda on that website, as well as membership meetings as well. No later than the date required for that notice, by the way. Okay. Member participation at board meetings. Okay. All meetings of the board are open to the members. There's two exceptions. Okay. And the two exceptions are meetings between the board and its counsel and its attorney with respect to proposed or pending litigation, where the contents of the discussion would otherwise be governed by the attorney-client privilege. In other words, the attorney is giving advice regarding the proposed or pending litigation. Okay. The other manner or reason to have a closed meeting is if you're discussing personnel matters. So personnel matters regarding employees, regarding, it could be, compensation, termination, hiring, suspension, discipline, whatever. If you're doing a personnel matter is being addressed at a meeting, that can be closed to the owners, as well as the one between the board and the attorney regarding litigation. By the way, those meetings still have to be noticed. I know it sounds illogical. They can be noticed as a closed meeting, okay, and owners are not allowed to attend. Otherwise, members have a right to attend all board meetings, okay, and have the right to speak at any board meeting with reference to all designated items on the agenda. The association may adopt reasonable written rules governing the frequency, duration, and manner of member statements, including requiring members to sign up on a sign-up sheet in order to speak. Now, unlike a member's right to speak at members' meetings, okay, where there's a 3-minute limit, okay, minimum limit, there is no statutory prescribed time limit for a member's right to speak at board meetings, although through rule, I think it's reasonable to adopt a 3-minute minimum time period, okay? Recording and handicap access, okay? Similar to members' meetings, an owner may tape, audio, or video, or record. I know tape is an old-fashioned term now. You can record either audio or video board meetings. And again, similar to members' meetings, the board can adopt reasonable rules regarding the recording of meetings. And similar to before, the board meetings must be held at a place or a location accessible to physical handicapped persons if it is requested by a physically handicapped person who has a right to attend the meeting. How about paying board members? I know you guys probably got this job because you thought it was a real moneymaker. Well, I hate to disappoint you. A director, officer, or committee member may not directly receive salary or compensation from the association for the performance of their duties as a director, officer, or committee member, and may not in any other way benefit financially from service to the association, except for these exceptions. They can participate in a financial benefit accruing to all or a significant number of members as a result of actions which are lawfully taken by the association, reimbursement for out-of-pocket expenses incurred on behalf of the association, subject to applicable approval procedures, in other words, the board approving that, recovery of insurance proceeds derived from a policy of insurance maintained by the association for the benefit of its members, any fee or compensation which is authorized by the governing documents or by a vote of majority of the voting interest, voting in person or by proxy at a meeting of the members. Can't say I've ever seen number 4 ever happen. Or a developer or its representative serving as a director, officer, or committee member of the association. How about kickbacks? Not so good. An officer, director, or manager cannot solicit, offer to accept, excuse me, or accept a kickback. So what is a kickback? I think most of us know that. A kickback is anything or service of value for which consideration has not been provided for an officer's or director's or manager's benefit, or for the benefit of an immediate family member from any person providing or proposing to provide goods or services to the association. So if someone's going to, paint the clubhouse, can't give the officer a bag of money to hire them to, or retain them to be the painter, or you can't have them paint the inside of your house for free. So no kickbacks, you can't get anything value for which consideration has not been provided. An officer or director who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. Also, an officer director who violates this provision must be immediately removed from office by the board, and that creates a vacancy filled until the end of that term of office of that person. However, what are the, exceptions, if you want to call them that? Okay, you can, food that is consumed at a business meeting with a value of less than $25 per individual, that's not a kickback. Or something, a service or a good received in connection with trade fairs or education programs. So when you go to these trade fairs, in fact, we're doing one next week, these expos, and people have the stuff on their tables, the swag, so to speak, those are not kickbacks. Get your pen, get your chip clip, other stuff at those expos. What about immediate removal? What are grounds for immediate removal? We already mentioned some of them. So this will be a little bit of a review from what we already mentioned. A director or officer that's charged by information or indictment with any of these following crimes must be removed from office. Again, this is a little bit of review. Forgery of a ballot envelope or voting certificate used in an election. Theft or embezzlement involving the association's funds or property. Tampering with physical evidence, as provided in section 918.13. Destruction of or the refusal to timely allow inspection or copying of an official record in furtherance of a crime or any crime. Obstruction of justice, and any criminal violation under the Homeowners Association Act. Any of those things occur, the person is immediately off the board. The board must fill the vacancy until the end of the period of the suspension or the end of the director's term of office, whichever occurs first. So, for example, if the charges are resolved without a finding of guilt or without acceptance of a plea guilty or nolo contendere, no contest, the director or officer must be reinstated. So if you've been charged with a crime for which you have to be removed, and then those charges are dismissed, okay, then the suspension from the board is over. You can go back on the board. While the criminal charge is pending, the person may not be appointed or elected to a position as an officer or director of any association and may not have access to the official records of any association except pursuant to a court order. Additionally, immediate removal. If you become more than 90 days delinquent, a director becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation, that would include an assessment, obviously, to the association, they're deemed to have abandoned his or her seat, creating a vacancy on the board to be filled. Now, again, unlike the other ones, which are temporary suspensions until the charges were dropped, in this case, if you're more than 90 days delinquent in the payment of any monetary obligation to the association, you're off the board, period. So even if you pay up that debt, okay, or pay up that obligation, being off the board is not suspension, you're removed. Maybe until the next election you can run if you're current, but this is not just a suspension. This is abandonment of your seat on the board. What about conflicts of interest? Directors and officers, including those appointed by a developer, must disclose to the association any activity that may reasonably be construed to be a conflict of interest You have to make that disclosure at least 14 days before voting on an issue or entering into a contract, which is the subject of that conflict. So what kind of things are conflicts? Well, there's a rebuttable presumption of a conflict if any of the following acts occur without prior disclosure to the association. So a director or officer or relative of director or officer enters into a contract for goods or services with the association, or a director or officer or a relative of director or officer holds an interest in a corporation, LLC, partnership, limited liability partnership, or any other business entity that conducts business with the association or proposes to enter a contract with the association. So let's say, for example, you run a pest control company and you have a financial interest, in that company, or a relative does. That has to be disclosed if that association is going to hire that pest control company to do services for the association. It's just one example. If you enter into a contract, the association enters into a contract, that is, with one of its directors or a corporation or entity in which the director is also a director or officer or has a financial interest in, okay, not including an affiliated HOA, then the board must comply with these following requirements. That proposed contract with the director, okay, or that entity, that company, must be fully disclosed to the board, and the disclosure entered into the minutes of the board meeting at which the proposed contract will be considered and voted upon, and it must be approved by 2/3 of the directors present. The contract or with the director must be, or that company the director has an interest in, must be reasonable and fair to the association. And then at the next regular or special meeting of the members, again, the owners, the existence of that contract or transaction must be disclosed to the unit, to the lot owners, to the membership. And then upon the motion of any member, the contract may be canceled by a majority of the vote of that at that meeting, okay? And then if the members cancel the contract, the association is only liable for the value of the goods and services that were, received or provided up to the time of cancellation, and they're not liable for any kind of termination fee or liquidated damages or any penalty. Quite frankly, in my side opinion here, I would steer clear of these conflict of interest type of transactions or contracts if possible. If there's a reason, some compelling reason to do it, just make sure you dot I's and cross T's with respect to all the disclosure and approval and voting requirements regarding that contract or transaction. Official records. Very important. So what are the official records of the association? Well, here's the laundry list of them. Copies of any plans, specifications, permits, and warranties related to the improvements on the common area, whether clubhouse, tennis court, roads, whatever, or other property that the association is obligated to maintain or repair or replace. All the governing documents, declaration, articles, and bylaws, and your rules and your amendments. You must maintain an adequate number of copies of the recorded documents to ensure their availability to members and prospective members. Minutes of all meetings of the board and the owners, a current roster of all members and their designated mailing address and lot identifications, and the email address and fax numbers for those members who have consented in writing to receive their notice by electronic transmission, and that consent has not been revoked. Any association or all associations' insurance policies, all contracts to which the association is a party, all bids received for work to be performed. They include all your financial and accounting records, kept in accordance with good accounting practices. For example, accurate, itemized, and detailed records of all receipts and expenditures of the association. A current account and periodic statement of the account for each member, designating the name and current address of that member, who is obligated to pay assessments, the due date and amount of each assessment or other charge against the member, the date and amount of each payment, and the balance due, if any. All tax returns, financial statements, and financial reports of the association. A copy of the disclosure summary, which is described in section 72401. That's a MARTA thing that Danielle's going to talk about. Ballots, sign-in sheets, voting proxies, and all other papers and electronic records related to voting by owners. You have to keep those for at least 1 year after the date of the election or the vote or the meeting. And then all affirmative acknowledgements made pursuant to 72308.5 Does the firm acknowledge and regard the manner in which the association sends the owners invoices, bills, or statements? Finally, there's a catch-all at the bottom of this slide. All other written records of the association that are not specifically identified, which are related to the operation of the association. So the official records, long story short, are very broad and basically include any kind of written record that's related to the operation of that association or of your association. You have to retain the official records for at least 7 years, unless your documents require a longer period of time. All bids received for work performed must be kept for at least 1 year, okay? In a law effective in July of 24, you must adopt written rules governing the method or policy by which the official records of the association are to be retained and the time period such records must be retained, and that information must be made available to the owners through the website or application. Now, what things are not accessible to owners? We just went through the whole list of official records. There are some things that owners are not entitled to or not accessible to. So what are those? Records protected by the attorney-client or work product privilege related to litigation. We'll talk about that in a second. Information obtained in connection with the approval of a lease, sale, or other transfer of parcel. So if your association under their documents has the right to approve sales or leases of lots, and there's a lease application or other information submitted in connection with that, that file, that information, that application is not accessible to the other owners. Now, in a gated community, information obtained in connection with the guest visits to owners or residents is not accessible. Social security numbers, driver license numbers, credit card numbers, email addresses, I mentioned that before, telephone numbers, fax numbers, emergency contact information, and any address other than is provided for association notice purposes, requirements, and other personal identifying information is not accessible, okay, to the other owners or to the owners, excluding a person's name, lot designation, mailing address, and property address. The association is not liable for the disclosure of protected information if it's included in an official record and is voluntarily provided by an owner and not requested by the association. Other things that are not accessible to the owners: personnel records of association or management company employees, medical records of owners or residents. By the way, medical records would include, for example, not the only example, but just one example that comes up a lot. If you're a no pet community, but you have to grant or you're considering granting an accommodation to someone for an emotional support or service animal, and there is records that they provide you, a letter from a doctor, a letter from a psychiatrist, whoever, regarding that person's disability and need for the animal, that's a medical record, okay, and that's not accessible to the other owners. It can be reviewed by the board for purposes of determining whether to grant the accommodation, but it is a medical record not accessible to the owners. Any electronic security measure that is used by the association to safeguard data, including passwords, the association's software, an operating system which allows the manipulation of data, even if the owner owns a copy of the same software that the association uses. And again, all affirmative acknowledgments made pursuant to 723.085, these are not accessible. Now, we mentioned attorney-client privilege. Basically, attorney-client privilege, and I'll talk about it first before the work product privilege. Attorney-client privilege applies basically to anything that the attorney sends to the board or that the board sends to the attorney, okay? And I would throw the management into that as well. So if what the attorney sends to the management or manager and what the manager sends to the attorney, okay, those communications, whether it's email, letter, fax, text, whatever, those communications are privileged and confidential. By the way, the attorney cannot waive that privilege. The board, if they wanted to, could, but the attorney cannot. Work product privilege is any record which is prepared by the association attorney or prepared at the attorney's express direction, which reflects a mental impression, conclusion, litigation strategy, or legal theory of the attorney or the association, and it was prepared exclusively for civil or criminal litigation or for an adversarial administrative proceeding or anticipation of litigation or proceeding until it's been concluded. So those are things, again, where prepared by the attorney or at the direction of attorney and related to litigation or administrative proceeding, in addition to what I mentioned before, those direct communications between the board and the attorney. The correspondence from the association lawyer, attorney, again, like I said, remains privileged unless the board votes to waive the privilege, and only the board can waive it, the attorney cannot. You can print and distribute to the owners a directory with the name, lot address, and phone number of each owner. However, an owner can exclude their phone number from the directory by requesting in writing to the association. So if you're going to have a directory prepared with phone numbers in it, you have to give the owners the opportunity, the reasonable opportunity to opt out or exclude their phone number from being included in the directory, which is distributed. An owner can also provide, if they want to, voluntarily consent to disclosure of other contact information which is otherwise not accessible. So if an owner agrees in writing, for example, to disclose their email address to the other owners, he or she can, or they can, but it has to be pursuant to a voluntary, disclosure agreement where they agree to that disclosure in writing. Providing the rules and covenants. Okay, effective in July 1st, 24, before October 1st of 2024, an HOA, Homeowner Association, was required to provide a physical or digital copy of the association's rules and covenants to every owner, to every member. And an association must also provide a physical or digital copy to every new owner or every new member. So you had to provide it to the existing ones before October 124 and every new one. If the rules or covenants are amended, you must provide everybody with an updated copy of the amended rules or covenants. You can adopt rules establishing standards for the manner of distribution and time frame, providing copies of the updated rules or covenants. You can comply with this requirement by posting a complete copy of the rules and covenants or direct link thereto on the homepage of the association's website, if the website is accessible to the members of the association, and you send notice to each member of the association of the intent to utilize the website for that purpose by email to any member who has consented to receive notices by electronic transmission, like I mentioned before, and have provided an email address to the association for that purpose, and for all the other owners, mailing to those members at their address identified as the member's mailing address. You can mail them that notice about where the covenants and rules are available. Access to official records. So we talked about what the official records are. We talked about what official records are not accessible. Okay, how about when an owner makes a request? Okay, unless otherwise provided by law or the governing documents, the official records must be made available for inspection or copying by an owner within 45 miles of the community or within the county that the association is located in, and within 10 business days, working days, after receipt of an owner's written request. In order to comply with these requirements, the association may have a copy of them available in the community, may make the records available electronically via the internet, or allow the records to be viewed in electronic format on a computer screen and then printed upon request. If a request is submitted by certified mail, return receipt requested, and access is not timely provided, that creates a rebuttable presumption that the association willfully failed to comply. So with certified mail requests and you don't comply, that creates a presumption that you willfully failed to comply. A member who is denied access or has failed to provide access to the official records is entitled to actual damages, if any, okay, or the minimum damages for the failure of the association to comply with the records access. The minimum damages are $50 per calendar day, up to 10 days, and that calculation begins on the 11th business day after receipt of the written request for the records. If you receive a subpoena for records from a law enforcement agency, you must provide a copy of the records, or otherwise make the records available for inspection and copying to the law enforcement agency within 5 business days after receipt of the subpoena, unless otherwise specified by the law enforcement agency or subpoena, and you must assist the law enforcement agency in the investigation to the extent permitted by law. Official record crimes. So there's crimes related to official records activities by the association or by the directors. So what are those? Any director or manager who knowingly willfully and repeatedly, which means 2 or more times in a 12-month period, fails to provide access to the records with the intent of causing harm to the association or one or more of its members commits a second-degree misdemeanor. Any person who knowingly and intentionally defaces or destroys accounting records during the period in which the records are required to be maintained by the association, or who knowingly or intentionally fails to create or maintain accounting records that are required to be created and maintained, again, with the intent of causing harm to the association or one or more of its members, commits a first-degree misdemeanor. And any person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, that's a third-degree felon. That person commits a third-degree felony. Okay, you can adopt reasonable written rules governing the frequency, time, location, notice, records to be inspected, and manner of inspection. I would actually encourage boards to do this. It does control the record inspection process. The rules must be reasonable, and I think in generally that they're in the best interest of the association. However, you cannot require an owner show any proper purpose for the inspection. So even if it's your worst enemy in the community and you think this person is, just the worst person ever, and they want the records for some nefarious reason, you cannot require that person to show or disclose any reason or any purpose for wanting the records. Similarly, you can't require the owner to state any reason for the inspection, and you cannot limit an owner's right to inspect records to less than 1 8-hour business day per month. What about copying them? Because they have a right to inspect and to copy. Well, an owner or member or their authorized representative is allowed to use a portable device or a smartphone, scanner, or other technology capable of taking photographs to make an electronic copy. You can't charge them for using their own device. If an association has a photocopy machine available where the records are maintained, it must provide owners with copies on request during the inspection if the entire request is limited to not more than 25 pages. You can charge up to 25 cents per page for copies made on the association's copier. If you don't have a copier, or if the records requested exceed 25 pages, then you may have them made by an outside duplicating or copying service and charge the actual cost of that copying supported by an invoice from the vendor or from the copying service. What about personnel costs? You can charge, or you may charge costs required for personnel to retrieve and copy the records if the time spent exceeds 1/2 hour and if the personnel costs do not exceed $20 per hour. However, you cannot charge personnel costs for record requests that result in copying of 25 or fewer pages. Website, we've already mentioned this a little bit. Repeat. By January of last year, if you have 100 lots, you're required to have a website or a downloadable app, okay? The website or app must be accessible through the internet and must contain a subpage, web portal, or other protected electronic location that's inaccessible to the public and accessible only to the owners and employees of the association. Upon written request by an owner, the association must provide the owner with a username and password and access to the protected or private sections of the website or app, which contains the association's official documents. These are the things that must be on the website. All your governing documents, declaration, articles, bylaws, and all the amendments, your rules, current rules, a list of all current executory contracts or documents to which the association is a party, or in which the association or the owners have an obligation or responsibility, and after bidding for the related materials, equipment, or services, a list of bids received within the past year, your annual budget, and any proposed budget to be considered at the annual meeting, the financial report and any monthly or income expense statement to be considered at a meeting, the association's current insurance policies, and the certification of each director, i.e., what you're going to receive today, or not today, but over the next several days, the certification for this course. That certification for every director must be on the website or the app.
Thanks, Peter. You almost gave me a heart attack there.
Yep, sorry. Today. All contracts or transactions between the association and any director, officer, corporation, firm, or association that is not an affiliated. So in other words, any of these conflict of interest transactions or contracts they must be posted on the website, or any possible conflict of interest. Notice of any board meeting, the agenda, and any other document required for the meeting, that has to be posted not later than the date required for the notice. So if it has to be posted on the property 48 hours in advance, it has to be on the website 48 hours in advance. If it has to be posted 14 days in advance and sent 14 days in advance, then it has to be on the website 14 days in advance. Those two things are congruent. Notice of any membership meeting and the agenda for that meeting at least 14 days before the meeting, posted in plain view on the homepage or on a separate subpage of the website. It has to be labeled notices, and that must be conspicuously visible and linked from the homepage. You must also post any document to be considered and voted on by the owners during the meeting, or any document listed on the meeting agenda. Those documents must be posted at least 7 days before the meeting at which it's going to be considered by the membership. You must ensure that the information and records which are not accessible, and we talked about those before, are not posted. So all that stuff that owners don't have access to, the information owners don't have access to, that's not to be posted on your website or your app. If protected information or information restricted from being accessible are required to be posted in other words, if you have a document that's required to be posted and it has protected information, you have to redact that before posting it. If the association or its authorized agent is, however, the association or its authorized agent is not liable for disclosing protected or restricted information unless the disclosure was made with a knowing or intentional disregard of the protected or restricted nature. So if it's an inadvertent oops, and it wasn't knowing and it wasn't intentional, then there's no liability. You should still correct it as soon as possible by taking that stuff off the website or redacting it, but you're not liable if it wasn't a knowing or intentional disregard of the protected nature of the information. Finally, or at least finally for my section, amending the governing documents. Unless your documents require otherwise, okay, amendments must be approved by the affirmative vote of 2/3 of the voting interest. But normally, almost all documents, deck, articles, or bylaws will have its own amendment procedure or process in the document, and that's the vote required. If the documents don't, then it's a 2/3 vote of the owners. Amendments to the articles and the bylaws which affect or impose a quorum or voting requirement greater than the general amendment or quorum requirement are not required to be approved by that greater quorum or voting requirement, then in effect are proposed to be adopted when the lower threshold, when voting to lower that threshold, that voting requirement or amendment requirement. Now the format has to be that all new language that you're adding to the text is underlined. Anything you're proposing to delete or remove must be stricken through either with a line or with hyphens. However, if that's going to be so extensive that it's difficult to read or understand, then you can include the language, substantial rewording, see governing documents for current text, and you can just include a nice clean version of the text, and then the owner is referred to your existing document to compare it. So if the strike through and underlines make it like looking like hieroglyphics, you can use that to make it easier for the owners to read. Finally, if you require lender consent for amendments, and a lot of documents do, okay, then under 72306 1D, there's a process, there's a procedure to provide those amendments to the lenders, to the mortgagees. And if after 60 days they do not respond, then they're deemed to have consented to the proposed amendment, but jump through the hoop of at least presenting them to them for approval for that 60-day period.
Well,
And finally, I
done.
think it's finally, yeah, for me anyway. An amendment to a governing document is effective when recorded in the public records of the county, and within 30 days after recording an amendment to the documents, you have to provide copies of it to your owners, to your members. However, if you provide them a copy of the amendment beforehand, when you did your meeting notice, and then you can just send them a notice that it's been recorded and that a copy is available upon written request at no charge to the member. That notice must also provide the record book and page number that it's recorded at. However, if you screw up and don't do it, the failure to timely provide notice of recording does not affect the validity or enforceability of the amendment. I'm not saying don't do it. You should provide them notice that it's been adopted and send them a copy of it if you haven't done it already, and the book and page number. But just be aware that there is this escape clause, this escape hatch if you fail to. Okay, I know I ran over by a few minutes. Mea culpa. The star of the show is next anyway.
Oh, please.
You guys, thank you. And I will now turn it over to Danielle.
Is it tag I'm it?
You're it.
Just
Tag.
about,
All
just
right.
about.
Well,
Thank you.
Oh,
I
Jeff's
know.
gonna say something.
Yeah, just a quick thing, Peter. I know you have to run, so thank you for filling in for Kirsten early. Some of you might have been expecting Kirsten at the beginning if you hadn't seen the later ads. So Peter and
I
Danielle
got
have
stuck in
stepped
me.
up. Take care of yourself, Peter. Folks, if you haven't already done so, I want to take this opportunity now, before we continue. Make sure you press the chat button so the chat area appears so that you can see it. That's where we're going to place the link for the required evaluation a little bit later on towards the end of the class. A lot of you are asking, so please pay attention to what I'm going to say next, okay? That is where, after you fill out the evaluation, later on, you'll hit submit. You'll get another screen. That screen will have all of our contact information as well as the link to download and save today's slides. All right. And also, Skip from Hawkeye has not shown up yet. Apparently, the tech issues have reared their ugly heads over there. We want to say, Skip, hope everything's okay. I know some of your clients and colleagues are here today. Hope everything's okay. We hope to see you soon. We've got this. Don't worry about it. Thanks for collaborating with us. And now let's turn it over to what's that?
The streets were coming out there, huh?
The
streets in your voice.
The New York, yeah. The New York was coming out. Danielle, take it away, my friend.
All righty. All right. So we're just going to go ahead and jump right in. Let me get my screen share going for you. All right. So this particular section of the presentation has just a potpourri of items that are worthwhile to discuss, but don't have enough information to have their own separate section in the presentation. So just a few gems that y'all should know as board members of your HOA. So you are a homeowners association, obviously governed by Chapter 720 of the Florida statutes, but as Peter was mentioning earlier, you're also Florida not-for-profit corporations under Chapter 617 of the Florida statutes. So you do still have to comply with your governmental filings as a corporation not-for-profit. Excuse me. So with the division of corporations, you do have to file the annual report. It's very simple to do online. You tell them the information, confirm your mailing address, principal address, your registered agent, all your officers and directors and their addresses. You file that every single year. There's a small nominal fee for doing that. I think it's in like the $60 range. And you do also have to file annual income taxes. Even though you're a not-for-profit corporation, you're not a charitable corporation, so you do have tax filings as well. Meeting minutes. This is often something that gets a little bit confusing for board members when it comes to how much information do we need to put into our meeting minutes. Well, as a starting point, all meetings have to have minutes. And they don't have to be verbatim records. You don't have to put in Johnny said this, Sally said this. You just have to provide like what was the motion, who spoke, maybe some of their what the discussion was about, not the actual words that they said, what the vote was, what the tally of the vote was, and what was the result of that vote. They have to be maintained in written form or in another electronic format that could be converted into a written form within a reasonable time. And for our board meetings, vote or abstention from voting on each matter that's voted on by the board has to be put in your meeting minutes. So make sure that you are in fact recording who's making the vote and what the vote was for the board. Material alterations. So this is usually a big topic for our condominium clients, not so much for our homeowners associations because as Peter had mentioned earlier in the presentation, versus the common areas versus the common elements. Common elements in a condo are owned by all the owners in undivided interests, whereas in a homeowners association, our common areas are owned in the name of the association. So title is held by the association. Because title is held by the association has ultimate control of the common areas when it comes to making improvements and alterations to them, unless your governing documents provide otherwise. So this is something that is going to be very governing document specific. Look at your governing documents, make sure there isn't some kind of provision that would require membership approval for an alteration or addition to your common areas. Think of maybe putting in a tennis court or making that tennis court into pickleball courts, which seems to be the popular thing to do these past several years. Look at your governing documents. Is there membership approval required or not? Also, you want to be looking at the dollars and bills as well for the project. Figure out if you don't have the money in your operating and you need to levy a special assessment for it, you're going to want to look at your governing documents again to make sure that the board can levy the special assessment versus the special assessment needing to be approved by the membership. Our rules and regulations. So the association, meaning here the board, can adopt rules and regulations pertaining to the use of the common areas, the rec facilities, and lots if the governing documents so provide. So you're going to want to look at your governing documents. Usually, well, actually, it can be in all three. Usually in the declaration, sometimes in the articles, sometimes in the bylaws, where it will provide the board with the authority to adopt rules and regulations. Now, again, these rules are usually adopted by the board. However, sometimes governing documents do require membership approval of board adopted rules, or may even provide the members with the right to veto the board adopted rules. So look at your governing documents, see what the process is for adopting rules and regulations, and follow that process. Written notice of the meeting at which the board will consider to adopt rules or adopt amendments to rules regarding parcel use. Parcel, just another word for lot. It has to be mailed, delivered, or electronically transmitted to the owners and conspicuously posted in the community at least 14 days before the meeting. This is one of those special board meetings that requires that longer 14-day notice. And if you are in a community with 100 or more lots, you're also posting this on the website with a copy of the proposed rule that's being adopted, or a rule amendment that's being adopted. Written notice of a board meeting at which any other type of rule is going to be adopted, like rules regarding use of the common areas. That just has to be conspicuously posted in the community at least 48 hours before the meeting. It's not a special 14-day notice. And again, if you're an association having 100 or more lots, you're also going to be putting that on your website with a copy of the proposed rule or rule amendment. The Marketable Record Title Act, which we refer to in short as MARTA. I know people who maybe have a residence in Georgia may be thinking, MARTA in Atlanta. No, this isn't a transit thing. This is having to do with having clean title to your property. So simply stated, the declaration of covenants will begin to expire on a lot-by-lot basis 30 years after it was first recorded. There are some exceptions to that, but again, this is an oversimplification of what is really a very involved legal analysis that happens on a lot-by-lot basis. But as a general rule of thumb, you're looking at 30 years from the date of original recording of that declaration. Pursuant to some fairly recent changes to law, at the first board meeting that follows the annual meeting, which is not your organizational meeting, the board is required to consider whether or not they should file a covenant preservation to protect their covenants from extinguishment under MARTA, and to authorize and direct an appropriate officer to file that covenant preservation. Even if your community is not anywhere near that 30-year mark, you still have to do this as a requirement of law. Now, the covenants can be preserved for an additional 30 years by one of a few methods. One being the written notice under this particular statute, 712 of .06. 712 is the Marketable Record Title Act. This basically has a statement of marketable title that gets adopted by the board, and then you record a notice of the board having adopted that. However, more and more associations are using the summary notice provisions under Chapter 720. It's like a statutory form that's set out there that you just plug in the information, have it approved by the board, get it recorded, and then you send out that copy of that recorded notice to all of your owners. Very simple, something done by the board. Now, this third option is something that gets approved by the members, right? Because we're talking about amending the declaration. So if you're within that 30 years and you have something that you want to amend, well, that amendment could also count toward your covenant preservation under the Marketable Record Title Act. If you're approaching that 30-year mark, this may not be the best decision for your association because, again, membership has to vote to approve that amendment. And some, depending on your governing documents, it could be a supermajority of 75% that has to approve. So if you're going to if you're wanting to tie in your MARTA covenant preservation with an amendment, make sure it's something that you're doing well in advance in the event that the owners don't approve it the first time around, or to have it be done with something that's not controversial, like maybe amending, I don't know, your pet provision to allow pets or not. Well, that could be controversial too, but something that is simple that you think will get passed by the owners. I would not tie it to something that's going to be that the board thinks might be disapproved by the membership. For revitalization, if you don't preserve your covenants timely, meaning within that 30-year period from the date your declaration was originally recorded, you're going to have to undergo a covenant revitalization. That process is very intensive. You end up having to create an organizational committee that puts all the governing documents together, mails it out to the membership. Membership then has to approve it. After it gets approved by the members, then a package gets created and sent to the Department of Commerce. Department of Commerce then reviews the package and issues either a letter of approval or a letter of rejection, and will provide you with the reasons for the rejection. If you get a letter of approval, then all of those documents have to be recorded with the official records of the county and your community is in, and then a copy of that recorded document gets mailed out to everyone else. And then certainly there are issues that could be created with potentially with your assessment rights. So you really want to be focusing on that 30-year mark and making sure that you have your covenants preserved prior to that date. Now, for our emergency powers for homeowners associations, unless your governing documents prohibit it, the board can exercise emergency powers in response to a state of emergency that's declared by local government. These emergency powers are only available to the board for a period of time that's reasonably necessary to protect the health, safety, and welfare of the association and its owners and the residents and guests there. What that exactly means, we don't really have any great precedents for, so it's your guess is as good as mine there. These emergency powers include conducting meetings, whether it be by telephone, real-time video, or some other real-time electronic video communication, after providing notice in a practical manner as possible. So it's not going to be as strict as it is for meetings that are being noticed during a non-state of emergency time. The association's board can also cancel and reschedule meetings, designate assistant officers who can step into the shoes of the officer in the event that they're incapable of fulfilling their duties, change the principal address, enter into agreements with local government to assist them with debris removal, have a disaster or emergency plan, or determine that any portion of the common areas is unavailable for entry if it's unsafe to do so. They can determine whether the common areas can be safely used based on the advice of emergency management officials, public health officials, or licensed professionals retained by or otherwise available to the board. They can mitigate further damage, injury, or contagion. They can levy special assessments without a vote of the members, even if it's required to be approved by the members in the governing documents. Without the owner's approval, they can borrow money and use association funds as collateral, assets as collateral to fund those emergency repairs. And finally, with regard to emergency powers, notwithstanding the board's emergency powers, the association cannot prohibit owners, tenants, guests, agents, or invitees of an owner from accessing the common areas for the purpose of coming in and out from the lot, and when necessary in connection with either sale, lease, or other transfer of the lot, or habitability of the lot for health and safety of the person, unless local government says that they cannot access the parcel. Debit cards. The association and its officers, directors, and agents cannot use a debit card that's issued in the name of the association or billed directly to the association for the payment of any association expenses. Despite this prohibition, there is some language with regard to a person who uses a debit card that is issued in the name of the association or billed directly to the association. If they were using it for something that's not a quote unquote lawful obligation of the association, well, then they've just committed the crime of theft. Now, the term lawful obligation of the association is an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or in the budget that gets adopted by the board. The association can institute, maintain, settle, or appeal actions or hearings in its name on behalf of the members when it comes to matters of common interest to the members, including the common areas. Maybe there was some kind of construction defect issue, representations of the developer pertaining to any existing or proposed commonly used facility. You see that obviously most often right after turnover, when control of the association has gone from the developer to the owners. Protesting ad valorem taxes on commonly used facilities and defending an eminent domain lawsuit or bringing an inverse condemnation claim. This is when government will come in and try to purchase or take portions of the property. Like, for example, we had an issue with that when they were widening I-95, something like that. Before beginning litigation against any party in the name of the association, which involves an amount in controversy in excess of $100,000, the association must first obtain the affirmative approval of majority of the voting interests at a meeting of the members at which a quorum has been obtained. So that's not a majority of the total voting interests, it's a majority of the voting interests that are present at that meeting in person or by proxy. Oh, now one of our favorite sections. I think this is architectural control is probably one of the most important functions of a homeowners association. I think it's one of the reasons why a lot of people choose to live within a homeowners association is because the aesthetics of the community and what your neighbor can and cannot do to their property is controlled and kept in a cohesive aesthetic throughout the community. For our architectural standards and guidelines, now this is fairly new law that became effective July 1st of 2024. The association has to reasonably and equitably apply and enforce on all owners their architectural and construction improvement standards or other published guidelines, which are authorized by the declaration. Obviously, here think of potential claims for selective enforcement, which is one of the most favorite defensive claims by owners, right? If the association denies an owner's request for an improvement or alteration to their lot, the association must provide written notice to the owner stating with specificity what rule or covenant the association is using as a reason for denying that request. and what aspect of the proposed improvement or alteration that does not conform to that rule or covenant. So you really need to look at your architectural standards and guidelines, make sure that all the improvements that could be contemplated by an owner in your community are covered in there, because you're going to need to point to something as authority for refusing an owner's requested alteration to their lot and tell them how that request does not comply. The association cannot enforce or adopt a covenant rule or guideline that would limit or place requirements on the interior of a structure when it's not visible from the lot frontage, from another lot, adjacent common area, or a community golf course. And they cannot adopt a covenant rule or guideline that would require the review and approval of plans for a central air conditioning, refrigeration, heating, or ventilation system. If that system's not visible from the lot's frontage, another lot, an adjacent common area, or the community golf course, and is basically the same to the system that was approved or recommended by the association. Regardless of whatever covenants, rules your association may have, and unless it's prohibited by general law or local ordinance, the association cannot restrict owners or their tenants from installing, displaying, or storing any items on the lot which are not visible from the lot's frontage, an adjacent lot, an adjacent common area, or community golf course, including, for example, artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. This was fairly new several years back. There was a change made to this by later legislation, and that's why you're seeing that text in blue italics there. That was language that was added by more recent legislation. For our hurricane protection is something that is discussed heavily for our condominium associations, but more recently added to the Florida statutes concerning homeowners associations, being effective as of July 1st of 2024. The association must adopt hurricane protection specifications for each structure or improvement on a lot that's governed by the association. Hurricane protection would include, for example, roof systems, storm shutters, impact windows and doors, reinforced garage doors, erosion control, generators, other hurricane protection products that are used to preserve and protect structures on a parcel. The specifications have to comply with applicable building code and can include things such as color and style and any factor that's deemed relevant by the board. The association cannot deny an application for the installation or replacement of hurricane protection by an owner which would conform to those specifications, right? That makes sense. If it's complying with what the association is requiring, then the association must approve it. And the association can require that an owner adhere to existing unified building scheme regarding the external appearance of the structure or other improvement on the parcel. For example, if everyone in the community uses accordion shutters and this particular person wants maybe like a roll down shutter, nobody else in the community has a roll down shutter, well, then maybe the association can then say, no, you need to put an accordion, not roll down, because it conforms with the existing unified building scheme of our homes here. For our vehicle restrictions, the association's governing documents cannot prohibit an owner, tenant, guest, or invitee from parking their personal vehicle, which was defined to include a pickup truck, in their driveway or in any other area where they have the right to park as governed by governmental regulations. An owner, tenant, guest, or invitee from parking his or her work vehicle, regardless of whatever sign may be on that vehicle, which is not a motor vehicle as defined in this particular statute, in their driveway, or from operating a vehicle that's not a commercial vehicle in conformance with state traffic laws on public roads or rights of way or on their lot. So a lot of our associations after this was enacted, came to us and said, hey, wait, we prohibit commercial vehicles. We prohibit dually trucks, pickup trucks, from being parked within our community. How does this affect us? Well, we'll have to go back to what was discussed at the very beginning of this presentation concerning Kaufman language, right? So we view this as a substantive change to the law. So if your association prohibited commercial vehicles from being parked on a driveway, and then this law came into effect, it is our opinion that this law does not change the prohibition in your governing documents, because that change existed prior to the effective date of this legislation. Now, reasonable minds may disagree, but I don't see how this could be argued as being a matter of public policy or as being something procedural. So that is our position on the issue, but certainly reasonable minds can disagree. But if you are going to be amending your vehicle prohibitions, you would have to amend it in accordance with current law. For our contractors here, the association's governing documents cannot prohibit an owner from inviting, hiring, or allow entry to a contractor or worker on their lot solely because that person is not on a preferred vendor list for the association, or prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on their lot solely because that person does not have a professional or an occupational license. The association cannot require a contractor or a worker to present or prove having a license to allow entry onto that person's property. Now, the next couple of sections, or a few sections really, are about dollars and bills for our homeowners associations. So first, starting off with our budgets. The association has to prepare an annual budget that will reflect the estimated revenues and expenses for the upcoming fiscal year and the estimated surplus or deficit that's going to be carried over at the end of the current fiscal year. Usually the fiscal year is January 1st to December 31st. You want to look at your governing documents. Usually in your bylaws, it will provide for your fiscal year. Your declaration or your bylaws may provide for some budget adoption procedures. So you're always going to want to look at your governing documents when it comes to budget adoption. The budget has to set out separately all fees or charges that may be paid by the association for recreational amenities, whether they're owned by the association, developer, or another person. This may be applicable for our associations out there who have like a separate country club within their master community, something like that. The budget will include two main components: your operating expenses and your reserves, if you have reserves. As from a practical perspective, you're going to be using your prior fiscal year's numbers to plan for your expenses for next year. And monies that are in the operating section of your budget, even though they're under a particular line item on your budget, they're not really earmarked for that particular purpose. So the board can use money allocated to one operating line item for other purposes that may be authorized by the governing documents. Maybe you overestimated your budget for legal and you didn't need as much legal, but you want to use the funds to replenish your mulch for that year. Well, then you certainly can do that, so long as there's no prohibition in your governing documents otherwise. The operating expenses identify the categories of income and expenses that relate to your day-to-day operation of the community, such as your management fees, your maintenance fees, taxes, insurance, professional fees like your legal budget. They do need to be listed by account and classification and should project what your total annual expenses will be for that particular classification. Now, reserves for a homeowners association is very, very different from that of a condominium. Now, your budget might include reserves for capital expenditures and deferred maintenance, but whether or not these reserves have to be maintained in accordance with Florida statute or could be discretionary reserves is a material question of how can we reserve, or do we have reserves, and how can we spend reserve funds? So a little bit about what capital expenditures are and deferred maintenance. A capital expenditure is any expenditure of funds for the purchase or replacement of an asset which has a useful life of greater than 1 year, or to repair an asset that will extend that useful life for a period of greater than 1 year. And deferred maintenance is any maintenance or repair that will be performed less frequently than yearly and will result in maintaining the useful life of that asset. So, for example, and these examples are, pulled primarily from condo, which is pavement resurfacing for sure. Repairs or improvements in the common areas, sidewalk improvements, things like that. Now, reserves can be created in two different ways, right? The board can establish reserves and the members can establish reserves. But reserves that are not established by membership approval are not subject to the statutory limitations or requirements for funding. So if your reserves were not created by your membership, then really those reserves are just a piggy bank for the board to use in a rainy day. Reserves that are created by the members are created upon the approval of a majority of the total voting interest of the association. Once it's approved by the membership, then the board has to include that reserve account in its budget for the next fiscal year. Once it's established, those statutory reserve accounts have to be funded, maintained, or waived in the manner provided by the statute. You have to fully fund, and then the owners can waive or reduce the funding by a majority approval of the members present at a meeting at which a quorum is present. The amount to be reserved is based on the estimated remaining useful life and how much it's going to cost to fix it or replacement at the end of that useful life. The association can adjust the reserve assessments annually to take into account any changes in the estimates of useful life of a reserve item. Maybe they did some work on that particular item that made the useful life a little bit longer. So you have a little bit less that needs to go into reserves each year. The funding formulas for statutory reserves have to be based on a separate analysis of each asset in the reserve if you're using a line item reserve or a pooled analysis of two or more of the required assets. So a straight line would be, okay, pool replacement, this is how much longer our pool has. This is how much it's going to be to replace it at the end of useful life. Road resurfacing, how much longer our roads have, how much it is to resurface the roads. And then you would be allocating reserves for each separate item. Whereas in a pool, the two would be mixed together. And because you're pulling money from the pool at different times, your overall reserve obligation on an annual basis is supposed to be lower. So that's the idea about pooling your reserves. Unless your association maintains a pooled reserve, the reserve schedule should include each reserve account for capital expenditures and deferred maintenance or replacement as a separate line item with these following disclosures. So the total estimated useful life of that asset, estimated remaining useful life of that asset, estimated replacement cost or deferred maintenance expense of that asset, and the estimated fund balance as of the beginning for the period for which the budget will be in effect. As I said, when we have our reserves, we can have the straight line or we can have pooled reserves. Reserve funds and any interest that's accruing on those reserves has to remain in the reserve accounts, and it can only be used for those authorized reserve expenditures unless their use for some other purpose is approved by a majority vote of the members at a meeting at which a quorum is obtained prior to the expenditure. If you have straight lined reserves, you can change them to a pooled reserve by the approval of the members using that same vote by a majority vote of the members at a meeting at which a quorum is present. The difference we explained before about pulling the money at different times. Waiving, reducing, and terminating reserves. So again, the board has to adopt reserves as fully funded. And again, we're talking about statutory reserves. Once the board has established, okay, this is what the reserve funding requirement is for this fiscal year, they can present to the members the option of waiving or reducing the reserves. The proposed budget has to include the statutorily defined reserves, and the association must fund those reserves unless a majority of the voting interests present at the meeting at which a quorum is obtained votes to either waive or reduce the funding of those reserves. Now, that vote is only applicable for the budget year for which the vote was taken. And whether to submit that vote to the membership is something that the board determines. It's not a requirement by law. The reserve accounts that are created by statute can be terminated upon the vote of a majority of the total voting interest of the association. And once it's terminated, then that reserve is removed from the budget. The governing documents have to be reviewed. I mentioned this at the very beginning of this section. You have to review your governing documents to see what specific requirements there are for the adoption of your budget. Some governing documents will require a 30-day, and you have to mail or provide the owners with a copy of the proposed budget before the board adopts it. Some documents don't require that at all, so you're going to want to look at your governing documents for that. If your governing documents are silent, then the notice of the board meeting at which the proposed budget will be considered has to be conspicuously posted in the community at least 48 hours before the meeting. And again, if you have 100 or more parcels, you have to post it on the website with a copy of the proposed budget. Unless your governing documents require that the board provide a copy of the proposed budget to the owners prior to the meeting at which the board's going to adopt it, then you have to do so. However, it's not required by law. You can certainly consider sending it to your members prior to adoption. But after it has been adopted, then the board must provide the members with a copy of the budget or written notice that a copy of the budget is available upon request by the member at no charge. If it's requested, then a copy of the budget has to be provided to the member within 10 business days after receipt of the request, which is, I'm sure as Peter explained to you, that's the time frame for responding to a request for inspection of the association's official records. And by January 1st of 2025, the association with 100 or more parcels has to post a copy of the annual budget on their website or app if you have a downloadable app. Now that we have our budget, that budget is really what sets up our general assessments, whether your governing documents call it maintenance assessments or general assessments or regular assessments. Those are the assessments that are due on a regular basis, be it monthly or quarterly or annually, depending on what your governing documents provide for. Any other assessment is going to be a special assessment. Now, written notice of the board meeting at which a special assessment will be considered has to be mailed, delivered, or electronically transmitted to the members and conspicuously posted in the property for at least 14 days before the meeting. The notice, again, if you have 100 or more parcels, website posting as well. The notice of the meeting must include a statement that a special assessment will be considered and provide the nature of the assessment and should identify the estimated cost of the assessment. Once it's levied, the association should send written notice to the owners of that special assessment and allow the owners a reasonable period of time to pay that assessment. A special assessment that's not been paid can then be collected in the same manner as regular assessments by the lien and foreclosure process. And your governing documents also may provide for, voting rights suspensions and use right suspensions for delinquency greater than 90 days. And we'll talk more about that in a little bit. A requirement to provide an accounting. This is a fairly new law. An owner can make a written request to the board for detailed accounting of any amounts that they may owe to the association that's related to their lot. And the board must provide that information within 15 business days after receipt of that request. Once the owner makes that request, then they cannot make another request for the same detailed accounting for at least 90 calendar days. If the board fails to respond within that 15 business days, that constitutes a complete waiver of any outstanding fines of the person who requested that accounting, which are more than 30 days past due, and for which the association has not given prior written notice of imposition of the fines, which, as you'll see, is something that is required. So if you're not providing notice of imposition of the fine, you're not doing your fining process correctly. What happens if an owner doesn't pay their assessments? Well, assessments that are not paid when due will bear interest at the rate provided by the declaration or the bylaws, or if no rate is provided, then at 18% per year. Notwithstanding whatever the declaration or the bylaws may say, compound interest cannot accrue on assessments and installments on assessments that are not paid when due. So no interest on interest. An administrative late fee not to exceed the greater of $25 or 5% of the amount of each installment can be imposed if it's permitted by the declaration or the bylaws. Again, don't charge interest on late fees. Not on late fees, not on interest, okay? Attorney's fees and costs can be collected. Those that are incurred in collection can be collected and are often included as part of your assessment lien. For the application of payments, so the person is delinquent, maybe they've racked up interest, late fees, some attorney's fees because they were sent a notice of intent to record a claim of lien. How does the payment get applied? Well, first it goes to any interest that's that's been accrued by the association, then to the administrative late fee, then to the attorney's fees incurred in collection, and then finally to the delinquent assessment. So notice of late assessment. This is something that was added to the statute, I would say a handful of years ago. We call them NOLAs because it's much easier and we love our acronyms in the legal world. The association cannot require the payment of attorney's fees related to a past due assessment without first delivering a written notice of late assessment to the owner, which specifies how much is owed to the association and provides them with 30 days to pay that amount without the assessment of attorney's fees. So if they're wanting to collect attorney's fees on a delinquency matter, you have to send a NOLA. Now, the NOLA is something that is set forth in the statute. So there's a form there that you can use. The notice of late assessment has to be sent by first class United States mail to the owner at their last address as reflected in the association's official records. And if that address is not the lot address, then you have to send it to both that mailing address and to the lot address. The notice is deemed to have been delivered once it's mailed, and a rebuttable presumption that the association mailed the notice properly is established if a board member, officer, agent, or manager for the association provides a sworn affidavit attesting to that mailing. Now, let's say you've sent out your NOLA, 30 days has passed, owner still has not paid. At that point, usually the file is turned over to the association's lawyer for further collections. Now, the first notice that the attorney's collections department will send out is a notice of intent to file a claim of lien. That notice of intent to file a claim of lien is basically provides that owner with 45 days to pay up. And if they don't, well, then at that point, the association can record its claim of lien in the official records of the county where the community is located. Once that claim of lien gets recorded, then the collections department will send out a notice of intent to foreclose. That's another 45-day notice that says, hey, you've now got a lien recorded against your property. We're going to file a foreclosure action in 45 days of this notice. Then the owners will get another 45 days in order to pay prior to the association actually foreclosing on that property. Now, let's assume that if a person is not paying their assessments, they may not be paying their mortgage either. And when there is some monies due to the association and the mortgagee, the first mortgagee, comes in and forecloses, and there's something due to the association, well, then we have to look at how much is that first mortgagee going to have to pay to the association. A lot of times in governing documents that are developer based, meaning they haven't been amended, they will usually provide the first mortgagee who obtains title by foreclosure or by deed in lieu of foreclosure with a clean slate of assessments, right? If you have that type of language, I would suggest that you go and you amend your documents to provide for what's the statutory safe harbor. In this case, that first mortgagee would be entitled to pay the lesser of either the lot's unpaid common expenses and regular or periodic or special assessments that accrued during the 12 months prior to them attaining title, and for which full payments not been made to the association, or 1% of the original mortgage debt. These limitations for the first mortgagee liability will only apply if the first mortgagee initially joined the association as a defendant in the first mortgagee's foreclosure action. But usually the foreclosure attorneys for the banks are very good at ensuring that the association is named. A third-party bidder on a foreclosure property has joint and several liability for any past due assessments, meaning they're going to be responsible for all delinquencies that accrued on that property by the prior owner. However, if the association foreclosed and got title to the lot, the third-party bidder, and then the lender does its foreclosure. So assessment lien, assessment foreclosure, association obtains title. Maybe there's a lender foreclosure that happens after the association begins its foreclosure action. Then the lender forecloses on that property, gets title. The association's not going to be able to claim for payment for those assessments which may have accrued while the association owns the lot. So the association is not really considered a previous owner for the period of time that it owned the property. Turning to our financial reports, each year the board does have to prepare, complete, or have some other third party, which is more often the case, complete a financial report for the financial activities of the preceding fiscal year within 90 days after the end of that fiscal year, or annually on whatever date might be provided in your bylaws. Within 21 days after having that financial report completed, but not later than 120 days after the end of the fiscal year or whatever date is provided in the bylaws, the board has to provide each member with a copy of the financial report or a written notice that a copy of the financial report is available upon request at no charge to the member. Again, for those associations having the website requirement, look into that as well. Now, the level of financial reporting that the association is required to do depends upon the total annual revenue of the association. And you can look at these levels here. If you're $500,000 or more, audited financial statements, anywhere in between a reviewed financial statement, prepared compiled financial statement, or having less than $150,000, and you're preparing a simple report of cash receipts and expenditures. As of July 1st, 2024, regardless of your total annual revenues, an association that has 1,000 or more, at least 1,000 parcels, must prepare audited financial statements. But in reality, if you have 1,000 or more parcels, lots, you probably have total annual revenue of $500,000 or more. Now, if you're an association that has to have compiled and you want to move it up to audited, you can certainly do that. If 20% of the owners petition the board for a level of financial reporting that's higher than required, then the association has to notice and hold a meeting of the members to occur within 30 days of receipt of that petition for the purpose of voting to raise the level of reporting for that fiscal year. Once it's approved by a majority of the total voting interest, the association has to prepare that higher level of financial statement. A copy of that financial report must then be provided to the members within 90 days of the meeting or the end of the fiscal year, whichever occurs later. And the board must amend their budget or adopt a special assessment to pay for that heightened level of financial reporting, regardless of any provision that may require membership approval. Now, you can also lower the reporting level as well. If it's approved by a majority of the voting interest present at a properly called meeting of the association, then that reporting level can be lowered. The association cannot prepare a financial statement at a lower reporting level for consecutive fiscal years. So if you've done it last year, you can't do it this year. Now, pertaining to reserves, there is a particular disclosure that has to be provided in your financial report. If your budget does not include reserves, your governing documents don't require reserves, or if statutory reserves are not fully funded, then you're using that top disclosure there. And if your budget does not provide for statutory reserves but includes those discretionary reserves, that little piggy bank that I was talking about earlier, you would be using that second disclosure. Obviously, these are disclosures that your accountant, whoever does your bookkeeping, your financial report, will include for you. Contracts and bids for a homeowners association. Contracts have to be in writing if the contract cannot be fully performed within 1 year for the purchase or lease of materials and equipment, and if it's a service type contract. Regardless of these particular requirements, I would suggest that all contracts be in writing. You want to have a paper trail, especially if you think that there's going to be an issue concerning performance. All written contracts for operation, maintenance, or management of the association property should specify, okay, what are the obligations of the parties? How much is it going to cost? How often will the services be performed? How many people are going to be here performing these services? And I would also say, how long the term is going to be, your termination provisions, talk about indemnification, because those are going to be the things that may be of issue during the negotiation process. Bidding and whether or not that is required for your community. If the aggregate cost of the contract is more than 10% of the total annual budget, including reserves, the association must obtain competitive bids for materials, equipment, or services. There is nothing in the statute which provides, you must obtain 3 bids, although that seems to be the magic number for associations. There is no requirement, just more than 1. The association is not required to accept the lowest bid, and the association is not required to obtain competitive bids for products and services in emergency circumstances. The association is also not required to obtain competitive bids for products and services or when the business entity with which the association desires to contract is the only source within the county serving the association. Contracts that may have been executed before October 1st of 2004. I don't know if there are any that really exist like that. And any renewal thereof are not subject to the competitive bid requirements. Maybe this is like a telecom type of contract. The following contracts are not exempt, are exempt from the bidding requirements. They do not have to be bid out. Employees, attorney, accountant, architect, your CAM, but you could do it by, if you do it by competitive bid, you can have the term be for up to 3 years, an engineer, and a landscape architect. However, these are all service contracts, so they do have to be in writing. More with the dollars and bills for our association. Estoppel certificates. Within 10 business days of getting a written or electronic request for an estoppel certificate from an owner, a mortgagee, or from either of their designees, the association must produce an estoppel certificate. If the association has a website, they have to designate on their website the person or entity who is to receive the estoppel request and their contact information, be it a street or email address. Estoppel certificates have to be completed by a board member, authorized agent, or other authorized representative of the association, which could be a manager or employee of the association. Estoppel certificates have to be provided by hand delivery, regular mail, or email on the date of issuance. So the day that you complete that estoppel certificate is the day you have to send it out. Estoppel certificates must be signed by an officer or authorized agent of the association. And the statute does detail what the estoppel certificate has to include. So general information like the date of issuance, who the owner is, what the property is, if there's parking garage space number associated with the lot, attorney's name and contact information if the account is delinquent, and been turned over to the attorney for collections. Whatever the fee for preparing the estoppel certificate is, and we'll talk about the fees in a little bit, the name of the requesting party. Then the next section is about our assessments. How much are our regular assessments? Are there any special assessments on the property? Are there any other money due that to the association for this particular property? And finally, our other information. Is there a capital contribution fee or a transfer fee? Maybe the association requires approval of purchasers in this property, and there's a transfer fee for that. Whether the rules of the association would require approval for the transfer of the property, and if so, whether or not they have approved that transfer. Is there a right of first refusal? If they have a right of first refusal, has it been exercised? What's the contact information for any other association for which the owner is a member? Maybe you're a sub-association within a master association. You would be providing the master association's information there. Any contact information for the insurance maintained by the association would have to be that final piece of information there. So the estoppel certificate fees, this is something that's outlined by the statute. If there's not a delinquency, you cannot charge more than $250 for the preparation of the certificate. An additional fee not to exceed $150 can be added if there is a delinquency for that particular lot. If the person requests an expedited estoppel certificate, you can charge an additional $100 fee, and that estoppel certificate has to be provided within 3 business days after the request. In order to charge an estoppel fee, you have to have the authority to do so, and it has to be established by a written resolution that's adopted by the board or provided in a written management, bookkeeping, or maintenance contract. A lot of times they will be provided for in your management contract. And if the association fails to deliver the estoppel certificate within 10 business days of receipt of the request, the fee cannot be charged for the preparation and delivery of that estoppel certificate. If the certificate is requested together with the sale or mortgage of a property, but the closing does not occur, and within 30 days after the closing date, the preparer receives a written request accompanied by reasonable documentation that the sale didn't occur, then the fee has to be refunded to that payer within 30 days after receipt of the request. However, that estoppel fee is the obligation of the owner, so the fee can be still collected. Estoppel fees delivered by hand or email are effective for 30 days. Estoppel certificates delivered by mail are effective for 35. If additional information or a mistake is discovered on the estoppel certificate, then the association has to issue an amended estoppel certificate, and it becomes effective if the sale or refinance of the parcel has not been completed during the effective period. A fee cannot be charged for an amended estoppel certificate. So if you are issuing that amended estoppel, that's just a continuing obligation. It's not something you can charge separately for. And an amended estoppel certificate must be delivered on the date of issuance, and a new 30 or 35 effective day period begins depending upon the manner of how that was provided. An association waives the right to collect monies owed in excess of whatever amounts are specified in that estoppel certificate from a person who in good faith relies on the estoppel certificate and from their successors and assigns. So you want to be sure that the amounts that you're providing in that estoppel certificate are correct. Because if they're not correct, well, then you're going to be losing out on whatever monies aren't claimed in that estoppel certificate. Now, earlier you heard me mention voting rights suspensions, use rights suspensions for an assessment delinquency. Now let's actually dive into the details of what that means. The association is charged with the responsibility of uniformly enforcing its governing documents. Uniformly here, because remember, we're always concerning ourselves about the affirmative defense of selective enforcement, right? Specific covenants and restrictions that the board is responsible for enforcing could include those architectural standards, pet restrictions, leasing restrictions, parking restrictions, nuisance conduct within the community. Maybe you're housing for older persons and you have some kind of occupancy restriction concerning children, things like that. The failure of the association to enforce covenants and regulations in a timely manner could result in waiver or forfeiture of enforcement rights. Typically, the first step in covenant enforcement should include providing a written notice to the owner. Maybe if there's a tenant there, you're providing to the tenant and the owner a notice of that violation that includes, okay, this is the violation, this is the provision that's being violated, and either allowing them an opportunity to cure the violation if it's a violation that's subject to cure. Maybe their driveway is dirty and they need to pressure wash their driveway. Or just a warning to say, hey, you violated the governing documents, don't do it again, like maybe a parking violation. If voluntary compliance is not achieved, then the violation can be subject to further enforcement action like fines, suspension of use rights, suspension of voting rights, self-help if it's authorized by the governing documents, and then finally going through the mandatory pre-suit mediation process and then litigation. So fines and use rights suspensions for everything but failing to pay monetary obligations. So these are going to be for violations of the governing documents, like violations of the maintenance standards, of the architectural standards, of the nuisance requirements, parking, pets, leasing. The association has the authority to fine and suspend the use rights of an owner or their tenant, guest, or invitee for the failure to comply with the association's governing documents. The process begins with the board's levy of a fine or use right suspension at a properly noticed board meeting. Then the board will provide the violating party with 14 days written notice of a hearing on that violation. That notice has to include a description of the violation, the specific action that's required to cure the violation if it's subject to cure, and the date and location of the hearing, and access information if that hearing is held by telephone or other electronic remote means. The hearing has to be held within 90 days after issuance of that hearing notice before a committee of at least 3 members who are appointed by the board, and they cannot be officers, directors, or employees of the association or the spouse, parent, child, brother, or sister of that officer, director, or employee. The role of the committee is limited to determining by a majority vote whether they're going to confirm or reject the fine or use right suspension as it was levied by the board. If they don't confirm that fine or suspension, it cannot be imposed. If they do anything other than approve it, it's a rejection. The committee can hold their hearing by telephone or other electronic means. And if they do have to provide that access information in that 14-day notice, as previously mentioned. And the owner has the right to attend the hearing by the telephone or electronic means provided in the notice. Within 7 days after that hearing, the committee must then mail or email written notice to the violating party of their findings related to that violation, including whether there have been applicable fines or suspensions that the committee approved or rejected, if there hasn't been a cure, how the violation can be cured, if it's subject to cure, and the date by which the fine must be paid. If the violation's been cured before the hearing or in the manner specified in the hearing notice or notice of the committee's findings, then the fine cannot be imposed. So the statute, when it was amended to include this stuff, which is maybe only 2 or 3 years ago, wasn't super clear about when the cure can happen to excuse them from the fine after the notice of the committee's findings. So let's say the board levied the fine against the owner, sent out the 14-day notice. There was the hearing. The committee said, yes, we agree. They approved the fine. They sent out that notice 7 days after saying, hey, you're fine. You were fined, and your fine is due 30 days after delivery of this notice. And let's say 10 days after delivery, they cure it. Okay, fine, the fine cannot be imposed. But let's say over 30 days have passed. The fine has become due and they cure it. Is the fine then due, or is the fine wiped away? Statute isn't going to provide you with any kind of guidance there. So presumably, if the fine has come due, they need to pay the fine regardless of the cure after the fine, but it's not clear pursuant to statute. Now, as for the payment date of the fine, if the committee approves the fine, the committee must also set a date by which the fine has to be paid. And the date has to be at least 30 days after delivery of the notice of the committee's findings. So the committee needs to be a little bit clairvoyant here, or they need to build in some padded time for delivery of that notice, because it's 30 days after delivery of the notice that has to be taken into account when preparing the notice of the committee's findings. Now, attorney's fees and costs cannot be awarded against the owner that's based on actions taken by the board before the date set for the fine to be paid. So if attorney's fees are being incurred before then, it's not going to be compensable to the association from the owner until, whatever attorney's fees may accrue after the date set for the fine to be paid. If the violation and the fine that's levied by the board is approved by the committee and the violation is not cured or the fine is not paid per the notice of the committee's findings, then reasonable attorney's fees and costs can be awarded to the association. More about the particular fine and the use right suspension. The fine cannot exceed $100 per violation unless otherwise provided in the governing documents. And it can be levied on the basis of each day of a continuing violation with one notice and one hearing, but it cannot exceed $1,000 per violation in the aggregate unless it's provided in your governing documents. So yes, your governing documents can provide for fines to exceed $100 per fine or fines to exceed $1,000 in the aggregate. And if your governing documents don't, well, then maybe it's time to amend your governing documents to provide for it. A fine of $1,000 or more can become a lien against the lot and collected through the lien foreclosure process if the authority to do so is provided in the declaration. Again, something that may be the subject of an amendment for your community. A suspension of the right to use the common areas does not apply to those portions that are needed to provide access or utility services to the lot. And it cannot prohibit an owner or tenant of the lot from having vehicular and pedestrian ingress to and egress from the lot, including the right to park. The suspension will apply to the member and, where it's appropriate, the tenants, guests, or invitees of the member, even if the violation that resulted in that suspension arose from one of the multiple lots that may be owned by the member. So it could apply to all. Now, when the statute was amended, like I said, a few years ago, to revamp the finding and use right suspension process, there were a couple of special considerations that were added. So notwithstanding any provision to the contrary in the governing documents, the association cannot levy a fine for leaving garbage receptacles at the curb or end of the driveway within 24 hours before or after the designated garbage collection date or time, or for leaving holiday decorations or lights in their home longer than as indicated in the governing documents, unless they're left up for longer than a week after the association provides written notice of the violation to the owner. Now, a lot of boards have read this and have said, so why bother even regulating these things? Well, This isn't to say that you can't fine for these issues. It just means that you have to allow more time to pass or follow additional procedural measures before you can fine. So it's still worthwhile having the restrictions in your governing documents. It's just be mindful of these things when you're trying to fine them for these issues. Again, this is just for a fine. It's not for a use right suspension or any other manner of enforcing your governing documents. Now, our use right suspensions, we also have the authority to levy use right suspensions for an owner's failure to pay monetary obligations to the association for greater than 90 days. So that's not on the 90th day, that's on the 91st day. An association could suspend an owner's rights. I basically just said that. This particular issue is by board vote only. We do not need to have this heard by a committee and approved by a committee. This is simply by board action at a properly noticed board meeting. For the suspension to take effect, written notice of the suspension must be mailed or hand delivered or emailed if the owner has consented to receive notice via email to the association. To the owner, and if it's applicable to the occupant, licensee, or invitee of the owner's lot. The suspension of the right to use the common areas, again, does not apply to those portions used to provide access or utility services to the lot and cannot prohibit the owner or tenant of a lot from having vehicular or pedestrian access to and from the lot, including the right to park. Again, the suspension applies to the member and to the member's tenants, guests, or invitees, even if the violation is the result of one lot and not multiple lots owned by that member. And the suspension will end upon full payment of the delinquency. In addition to use right suspensions, we have the ability to levy voting rights suspensions. But this comes with a small caveat, as I'll mention. The association can suspend an owner's voting rights if the owner is more than 90 days delinquent in any monetary obligation to the association through board action at a properly noticed board meeting. Again, this is on the 91st day, not on the 90th day. However, there is some recent case law from a condominium that probably applies to a homeowners association because that's often the case. Even the Kaufman language issue that Peter spoke about earlier in the presentation is something that's borrowed from condominium law and has been applied to homeowner associations, so they usually fall in suit. This particular case basically said that if your declaration was recorded before the effective date of the amendment to the statute, which allowed for voting rights suspension, and there was no Kaufman language in the governing documents, well, then you do not have the authority to suspend voting rights. So if your governing documents don't have Kaufman language and don't include voting rights suspensions, and the association would like to suspend voting rights for an owner's failure to pay monetary obligations greater than 90 days to the association, then you certainly want to be looking into amending your governing documents to include that authority. For the suspension to take effect, same thing with the use right suspension. Written notice of the suspension has to be sent to the owner, mail, hand delivery, or email. And if it's applicable to their occupant, licensee, or invitee, the suspension applies to the member and to their tenants, guests, or invitees, even if that delinquency was resulting from one lot and not the multiple lots owned by the member. The voting interest suspension is not counted. That voting interest, it's as if it doesn't even exist because it's not counted toward the total number of voting interests for any purpose, whether it's to establish a quorum or to approve an action, including elections. The suspension will end upon full payment of that delinquency. Now let's assume you've sent notices, you've gone through the fining, you've gone through use right suspension use right suspension more so than it is for voting rights suspension, because really, when it comes to mandatory pre-suit mediation, we're not talking about dollars and bills. We're talking about violations of the governing documents, like the maintenance violation, like the leasing pet violation stuff. If all else has failed, then we move to the mandatory pre-suit mediation process. Now, this is for disputes between the association and an owner, and the certain disputes are subject to pre-suit mediation, other disputes are not. Those disputes which are subject to pre-suit mediation are disputes concerning use of or changes to the lot or the common areas, amendment to the association's governing documents, the conduct of meetings, access to the official records of the association, and covenant enforcement. Those disputes which are not subject to pre-suit mediation and can go directly to court are those having to deal with financial obligations, anything, an action to enforce a prior mediation settlement agreement, eviction or removal of a tenant or occupant from a lot, breaches of fiduciary duties, and recall and election disputes. Now, recall and election disputes don't go directly to court. They actually go to the Division of Florida Condominiums, Timeshares, and Mobile Homes. So that, I know it doesn't say homeowners associations, but yes, they do have jurisdiction over homeowners associations when it comes to these recall and election disputes. Now, the pre-suit mediation procedure is prescribed by Florida statute. Before you can file a lawsuit, the aggrieved party must first serve written demand to the responding party to participate in the pre-suit mediation process. The statute does provide a form for the contents of the pre-suit mediation demand. Basically, you'll plug in a description of the dispute, and then there's some text that has to be provided after that. That demand has to be served by certified mail return receipt requested, with a copy being provided by regular mail to the last address of that responding party that appears in the official records of the association. In that pre-suit mediation demand, you have to include a list of 5 certified mediators, and you do have to include information about them, like what their hourly fee, things like that, their contact information. Then once the responding party receives that pre-suit mediation demand, they have to respond within 20 days from the date of mailing of the written offer to participate in pre-suit mediation, either by certified mail return receipt requested, and by copy by regular mail to the address that's shown on that written demand. And in that response, they have to select at least one mediator that's listed in the demand that's acceptable to them. Once they've responded, now you know who that mediator is going to be. Then you have to schedule the mediation to occur at a mutually convenient date, time, and place within 90 days of the date of the written demand. However, both parties can agree to extend that timeline. The parties are required to share the cost of the pre-suit mediation equally, including the mediator's fee, unless the parties agree otherwise. And the mediator can require advance payment of their fees. Typically, in my experience, they'll only require the advance payment if if the owner is pro se, meaning they're representing themselves. The pre-suit mediation proceedings are privileged and confidential to the same extent as if it was a court-ordered mediation. So those persons who are not parties to the dispute cannot attend the pre-suit mediation conference without consent of all parties, unless it's counsel for the parties and a corporate representative designated by the association. If the mediation is attended by a quorum of the board, the mediation is not considered a board meeting for the purpose of notice and participation by owners. Again, these are confidential proceedings. So even though a quorum of the board is there, it's not considered a board meeting. Therefore, it does not need to be noticed and does not need to be open to the members. So let's say you get to the pre-suit mediation and nobody wants to agree. What happens next? Well, that would be considered an impasse. And at that point, you can go straight to court and file a lawsuit. However, that's not the only way that you can get to an impasse. An impasse occurs if the party fails to respond to that demand. So 20 days has come and gone. There's been no response. Let's say they don't agree to a mediator. They don't select one of the 5 mediators that's provided in your list. Let's say they don't make payment of fees and costs within the time established by the mediator. That would also be an impasse. What if they don't even show up? without being excused by the mediator. That would also be an impasse. And finally, the mediation, if it cannot be scheduled and conducted within 90 days after the demand was filed, could be an impasse unless the parties, again, agree to extend that deadline. Now, once there's an impasse, the party can proceed to court against the other party without further notice, and they can seek an award of attorney's fees and costs that were associated with the mediation. So the attorney's fees for that would be carried over into the litigation process. Now, generally speaking, attorney's fees are awarded only if authorized by contract or statute. In the event the person who fails or refuses to participate in the pre-suit mediation then prevails in litigation, they cannot recover attorney's fees and costs in subsequent litigation relating to the dispute. So if they were a bad actor at mediation but ultimately prevailed, they still don't get the prevailing party attorney's fees. If the dispute is not resolved at pre-suit mediation, then the prevailing party in any subsequent arbitration or litigation is entitled to seek recovery of their attorney's fees and costs that were incurred in pre-suit mediation. And finally, if the dispute was settled at pre-suit mediation, but an action for enforcement of that mediation settlement is sought, then the prevailing party in that subsequent arbitration or litigation is entitled to seek recovery of all of their attorney's fees and costs which were incurred in that pre-suit mediation process. So basically, if you're going to receive a pre-suit mediation demand or send one, make sure that you're complying with all the deadlines. Make sure you're participating in the pre-suit mediation. If you get into a settlement agreement, make sure you're sticking to that settlement agreement. Otherwise, you could be either not entitled to recover not entitled to recover your prevailing party attorney's fees, and you may end up having to pay for the other party's attorney's fees. And finally here, self-help. So your governing documents, likely your declaration, may provide the association with the ability to go onto an owner's lot to correct a violation on the lot and then to charge those expenses incurred to make the correction against the owner. This is usually called self-help. So if you hear that term, this is what we're referring to. Now, if your declaration provides for self-help authority, there's some recent case law that would require the association to attempt self-help, regardless of whatever risk may be imposed, before filing a lawsuit seeking an injunction with the court. An injunction is basically a fancy term for an order forcing someone to do something or prohibiting someone from doing something. In this case, we're really talking about forcing someone to do something. And why did the court come up with this? Well, an injunction is a remedy in equity. So we have two areas of law we're talking about: equity and at law. Remedies in equity, remedies at law. So in order to be entitled to a remedy in equity, you have to exhaust all your remedies at law, and then you can go into a court of equity. Now, because the injunction is a remedy in equity, it requires that there be no adequate remedy at law before it can be awarded. So if an association's declaration provides for self-help, then the association is able to correct the violation and then seek reimbursement from the owner, which is deemed an adequate remedy at law. So if you're able to get to those dollars and bills at the end of the day, that's an adequate remedy at law. However, depending on what district you're in, and I'm referring to District Court of Appeal. Here in Palm Beach County, we're 4th DCA. I believe it's 4th and 6th. At any rate, there is a disagreement between the District Courts of Appeal as to the application of this issue, because under Florida statute, the association has the ability to take enforcement as an option of different enforcement methods rather than having to follow a line of enforcement. Meaning we don't have to do this before this, before this, before this. We can do this or this or this or this. Um, so there's been a disagreement between the district courts, and this is something that's been sent over to the Florida Supreme Court for them to eventually hear and make a determination on. I don't know the details of when that's going to be taken up by the Florida Supreme Court, but hopefully we'll have some clarity on this and that will become the law of the land. So that is the end of the presentation. Thank you
Well
all for stopping by.
Very well
So
done. And
I'm going to go into the Q&A, and you Jeff, you wrap up.
yeah, before you thank you, Danielle. But take a look at some of the Q&A. What I'm going to do while you're doing that is go over a couple of things for everybody, because folks, the Q&A is not required. This is bonus time. You don't have to stay. Once you have filled out the evaluation and submitted it, you can go. You'll be fine. Okay, this is all bonus time. So, but being that the folks over at Hawkeye could not get on today for whatever reason, I do want to just mention on behalf of them, they did send me a little something to say, that on behalf of KBR and Hawkeye Management, we want to thank you all for spending part of your day with us. Now, this part is mine. Over at Kaye Bender Rembaum, we are committed to helping boards navigate their responsibilities with clarity and confidence. And we're always proud to partner with organizations like Hawkeye, who share that commitment in supporting education and the communities that they serve. And those of you with Hawkeye already know that. So programs like this are very, very important as part of that effort, because we make sure that board members have the knowledge and resources to effectively lead. So I hope you get that. I know this is not the most exciting stuff in the world to have to sit for 3 hours, but it's important stuff. Now, if you're currently working with a management company, and I know I said this at the beginning, and you're happy with that partnership, that's great to hear. Don't do anything. But if you are exploring a change, looking for additional support, the team at Hawkeye would be a strong resource for you. They do a great, great job, and I know Danielle can attest to that as well. You'll be able to find their contact information after you submit that required evaluation. I'll go over that in just a moment as well. So thank you again for all of your time and engagement. Okay, we appreciate the opportunity to work with you, and we hope you all have a great afternoon. So with all of that said, we have the link in the evaluation. We've put it in there a few times. Many of you are still asking about how to get the slides and save them. And Danielle, I promise I'll just be one more minute here.
No, you're fine.
Thank you. After you fill this sucker out, it's not as daunting as it looks. A lot of it is just point and click. But just make sure your email addresses match. Otherwise, it won't go through. Please don't type your name in all caps or your certificates will look funny. What else here? Anywhere you see an asterisk, it's a required field. And when you click the I'm not a robot, wait for the circle to stop spinning. Wait till you see the check mark and then hit submit, or it will not go through. Okay. Then this is the important part. This is what many of you are asking about. This is the confirmation screen. You don't get a confirmation email instantly. You don't get your certificates instantly. You get to this screen, okay? This screen here, bullet point number 4, the 4th bullet point. This is where you click to download and save today's slides, right here. Hover over the word here. If you're on a tablet, use your finger and just press it with your finger, and then you can save them that way. Now, when we send you your certificates within 5 to 10 business days, a lot of this information you see now will also be in that email. So if you couldn't figure out how to save the slides today, or you need Skip's or Hawkeye's information, or Danielle or Peter's information here, Danielle, that was not intentional. Sorry, you're not bold. You deserve to be bold, just like Peter. That information will be.
I am offended.
Boy, 2026. That's it. No, I'm kidding. So this information will be in the email you all get when we send your certificates within 5 to 10 business days. And be sure you keep tabs, just like the legislation says, when you agree to receive association business via email. It's your responsibility to make sure you have access to that email. So keep tabs on your spam and junk folders. If you have Gmail, for example, your inbox has all these crazy tabs at the top, like promotions and all these other tabs in your inbox. Sometimes the emails end up there. Okay. Now, if you're on the phone, let me see, anybody still here? Yeah, I still see a couple of listeners on the phone who aren't going to see the link. So you just go to kbrlegal.com. kbrlegal.com. Any page of the website at the top has a button for the evaluation certificate request. Click on that, submit that. We'll have your information. So let's see here. You don't see the evaluation. You're not going to see the evaluation. That's the link. We place a link into the chat. I'm going to do it again. There's the link. That's the link you click on. A tab will open up in your browser. Then you'll see the evaluation. Then you fill it out. I'll go over this again after Danielle tends to some of the Q&A. I'll share my screen again while doing it. Back to you, my friend.
Alrighty, so I'm going to start at the top. You guys have got some good questions here. What is the rule for spouses or partners of deed homeowners to attend meetings? So presumably this spouse or partner, because they're not on the deed, would not be considered a member of your association. And association meetings are open for members to attend. So they don't have the legal right to attend a meeting of the association. However, the culture of associations typically will allow for spouses or partners to attend, but they can be prohibited from attending your meetings. Next question, let me see. In an HOA, can board members be voted in by proxy, even if the HOA solicited candidates following the 60, 40, 35, 14 day notice structure? So HOA elections there's usually a lot of confusion around them. Even the best managers out there will apply a condo style election to an HOA. But when you're looking at an HOA election, you need to look at your governing documents because the statute does not have the same type of structure as a condo does. For an HOA, typically your election will be a 14-day notice with nominations from the floor of the annual meeting. So look at your governing documents, see how your voting is in your election, your nomination procedures. Maybe they do have a pre-nomination procedure in there and also provide for nominations, from the floor. So it's hard to say without looking at your governing documents whether or not voting by proxy, having a pre-nomination and a nomination from the floor is permissible. It could be permissible in your HOA. So it's a totally governing document dependent rule. Is an owner time limit speaking rule at a board and or member meeting per agenda item, other discussion item, or a net total accumulation of their used speaking time for any and all items, rule or law reference? Okay, so Florida statute, and I get condo and HOA mixed up for this all the time. Generally speaking, 3 minutes is used as a rule of thumb for the minimum amount of time an owner gets to speak as to each agenda item. Now, associations may sometimes put member statements to the end of a meeting in like good or welfare. In my view, that's not really what's intended by the statute. So the way that I run a meeting is, let's say it's even a board or a member meeting alike. You have your agenda item, a motion gets made, gets a second, then the board gets to discuss the item, then the members get the opportunity to make their statements concerning the item. It only makes sense to me to allow the owners to speak as to each designated agenda item prior to a vote on that item. Otherwise, why even bother speaking, right? If you're not going to be able to affect the outcome. Then after the members have made their statements, it gets called for a final vote tally. So there is no statute out there that requires that process, but here at KBR, that's the process that we use.
I'm going to say something that I know Danielle will appreciate as a fellow pop culture nerd. When you live in a community association, doesn't matter if it's an HOA or a condo or a cooperative, remember what Mr. Spock said to Captain Kirk when he saved the Enterprise from a planet exploding when he went into the dilithium chamber and knew he was going to die from radiation exposure. He said the needs of the many outweigh the needs of the few or the one. That line is a perfect fit for community association living. Wouldn't you agree?
Yeah. Yeah. I mean, there is a very much a utilitarian approach
Yeah.
to this business. So I think, usually when the biggest complaint that we hear from owners about our boards is number one, transparency, a lack of transparency. And number two, a lack of being heard. So they want to know what's going on and they want you to hear them. And I think that if you could open up the lines of communication, um, the more the better. However, you always want to keep it in a professional manner. So we shy away from and don't advise the use of social media as a means of communicating with your residents.
It's the devil.
Yeah, it really is because people get very courageous behind their computers, and say things that they wouldn't otherwise say in person. But I think it's very important for you guys to hear your members and then allow the membership to decide the way that they want to decide things, when it comes to their vote. And board, obviously, members can make their statements. The board will do what the board wants to do. But certainly remember why you're on the board. It's not for yourself, it's for your members. Anyway, let's go back to the questions.
And Mark, yeah, sorry, I just thought it was fitting based on that previous question. Mark, you're putting your question into the chat. Danielle is ignoring that the chat is for technical issues and the evaluation. If you have course related question, put them in the Q&A module, not the chat module. Danielle, back to you.
Okay, should an HOA board meeting to discuss hiring a new board attorney or interviewing a new board attorney be opened or closed? So meetings like that would be open. I don't see a reason why a board meeting to hire an attorney or management company would be closed because it's not a meeting that's subject to the attorney-client privilege. It's not regarding personnel. So assuming that the board is actually making a decision about hiring an attorney or hiring a management company, that meeting would be open. Let's see here. Is a workshop, homeowners and board member meeting, a requirement in an HOA? The board would rather hold a workshop prior to the board meeting schedule to avoid homeowners asking too many questions during the board meeting. Is conducting a workshop a valid alternative? So a rose by any other name still smells as sweet. If you are a quorum of the board meeting to conduct association business, that is a board meeting that requires notice and being open to the members, only subject to those very few instances where it would be a closed board meeting. Even closed board meetings do need to be noticed. They're just owners can't attend. So you can't use a workshop as a means of circumventing the notice and open meeting requirements. Can a board member disclose at a board meeting to owners the payment default and bankruptcy information history for a homeowner involved in a foreclosure or appeal of foreclosure action? So the association itself is not a debt collector when they're collecting their own debt for the purposes of like Fair Debt Collection Practices Acts. However, they should avoid doing anything that would embarrass an owner. It's not something that I would advise. Is it legally impermissible? It depends. It depends on what's being said. Not advisable. I don't understand what the relationship is between the bankruptcy and their existing foreclosure action unless they were unless the bankruptcy was started after the association had initiated its foreclosure action. maybe they're just providing a status and that could be taken as sensitive information, but I don't think that necessarily providing a status is inappropriate. Again, you have to be a fly on the wall to actually hear what they're saying to see if it's something that could be actionable or not by that owner. Um, let's
Susan
see.
in the chat, how do you know your evaluation was submitted? There's no confirmation. When you hit submit, it then goes to another screen. What I was sharing earlier, it's what I showed you with the yellow box. Uh, so Danielle, back to you. I'll be going over that again when Danielle's done with the Q&A.
Okay. Can members vote at membership meetings to amend governing documents as proposed by members? So yes, but there's going to be a process involved to actually get that meeting called. Certainly look at your governing documents to determine when the board is required to call and hold a special meeting of the members. Sometimes it's 10%, as low as 10%. Then certainly you could put together an amendment to your governing documents and have it voted at a special meeting of the members. You also want to be looking at what your governing documents say as to the membership approval requirements. So, if you don't think that you have enough members who would vote in favor of it, you want to do that legwork beforehand to get that done. Regarding the $100,000 ceiling, if a foreclosure action is contemplated and the appraised home value is 1.5 million, does this meet the $100,000 threshold that requires a present member vote? So when we're talking about the amount in controversy, we're not talking about the home value. It's going to be the delinquency amount. And hopefully your association isn't waiting until it gets to $100,000 in delinquency before it initiates its collections proceedings. So the focus there, just shift your perspective a little bit. Is there a specific amount that has to be held in reserve? Well, the threshold question is, do you have a statutory reserve, something that was voted upon by the membership, or do you have a discretionary reserve? If you have a discretionary reserve, there is no amount that has to be reserved. If you have a statutory reserve, then you do have to have a certain calculation for the reserve, depending upon the estimated remaining useful life of that asset and the deferred maintenance or capital expenditure costs at the end of that useful life. And then it gets amortized over the life of that asset. And then that would be the amount that you have to reserve for that particular fiscal year. However, that would also be subject to waiver or reduction by vote of the members. So it's a complicated question, easy enough question to ask, difficult to answer. You really need to look at not only your governing documents, but your association's official records, like your membership meeting minutes, to determine if you have a statutory reserve or if you have a discretionary reserve as a threshold question.
It's a pretty decent question at the very end, if you want to see it. The most recent one submitted about the directory.
Does this one from ML?
No, from
Culpepper?
John. John at the very, very end, the bottom.
Okay, Peter mentioned resident approval to list their phone or email in a directory. Must that be opt-in or can it be opt-out? So, phone numbers are going to be opt-out. The association can publish directory including the phone number unless the owner opts out. Now, when it comes to email addresses, an owner can certainly consent to the disclosure of email addresses in writing. But if you've provided your written consent to receive notice via electronic transmission, that email address is going to be subject to disclosure.
And there's also a
So,
difference, in associations, there's a difference between receiving emails about the upcoming dance in the ballroom on Saturday night versus official business, like the meeting is taking place on February 27th. Two different kinds of
right.
emails. So make sure if you're part of the board or a management team, you're very clear about what people are opting into.
Yeah. So if you want to use electronic notice meaning email or facsimile for those ancient folks who still have fax. I
I don't
don't.
have facts, but I guess I'm an ancient folk.
Or no, you're not. If you don't have fax, you're up with the times.
All right. Thanks.
So if you are going to if you want to send out notice via electronic transmission, be it email or fax, make sure that the association is obtaining written consent from the owners or electronic consent. They could put it into an email to the association saying, "Hey, yes, I'd like to receive my notice via email." Make sure that you have that consent in hand before you start using that as a means of providing notice of association meetings in lieu of mailing that notice. Certainly, certainly, certainly. Other discretionary mailings, like your monthly newsletter, you can send those via email. That's not something that's statutorily required. And if you're using an email for those means, but they have not provided their written consent to receive notice by those means, then that email address is not part of your official records. Okay, so you're not disclosing that email address to anyone. Let me see, let me scroll up.
And folks, the reason you see some questions answered in the answered area, that's because they were non-attorney related. I was able to answer them. The questions people are asking, you cannot see them. Only Danielle, only the speakers can see them. That's why you're not seeing them. A few of you are asking me that. Back to you.
We have in-house staff. If a staff sends a director an email such as, "We just installed that sign we talked about, take a look at your convenience," is that considered an official communication? That must not be deleted for years. So you're asking if this email is an official record of the association or not. Emails tend to be a little bit of a gray area for associations, especially homeowners associations, where this area of law is so underdeveloped, not developed at all. For condominiums, we've got a little bit of guidance from the Division of Florida Condominiums, Timeshares, and Mobile Homes through their arbitration decisions. But in HOAs, it's like wild, wild west. So we have to look to our condominium associations for guidance. Now, the current general rule is if it's director to director email that's done through either their personal email address or on their personal device, meaning it's not a device that was purchased by the association for them, or it's not an association, domain name that they use in their for their emails, like president@sunnysidehoa.com. Then those personal emails on the personal device are not going to be official records of the association. However, if you put the manager on those emails, then that becomes an official record of the association. Now, when it comes to staff, arguably, that's akin to including the manager on the emails, and I would take the position that they are official records of the association. So, can you take that as, the word of Hoyle? No, you can't. Nobody can, not even other attorneys, because, like I said, this is not a developed area of law, but what we do know is what's been provided by the division, as I just discussed. So take from that what you will.
Danielle, I sent you something in the chat. Can you take a look real quick? Directly to you. It starts with can HOA added a requirement about a minute ago.
Okay. Okay. HOA can add a requirement for access to official records to submit requests by certified mail. So presumably the HOA's board adopted a rule that requires that official records requests be sent by certified mail. Okay, can that request ask for inspection of future records, i.e. ask for monthly delinquency report for the next year as opposed to having to send certified mail every month? So no, you will need to make the request every month. The associations can't produce documents for you on a go-forward basis. When the association receives an official records request, and yes, they can adopt rules governing the frequency, manner, method of providing the request and conducting the inspection. It's going to be whatever records are available as of that date of inspection. It's not going to be something that is prospective. So yes, you'd end up having to make the request.
I need to address something here because there's so much education confusion with lately. So I'm a board member. Is this a 4-hour credit? The answer to that is this is the certification class. That's not a CEU class, but this does satisfy 4 CEs for HOA board members once every 4 years. However, this isn't going to fall into that for you today because this class is only 2 years old. So you should have taken, if you've been on your board, Karen, since this law went into effect, when this class became pertinent back in July of 2024, when it passed that we have to have this new version of this certification class, you should have taken this by now if you've been on the board since then. If you're a new board member and you're taking this for the first time, this is all you need this year, unless you're in an HOA that is over 2,500 parcels and you need another 4 CEUs. I hope I didn't confuse you even more, but I have that in writing from the division.
All right, so I'm going to do a couple more questions, and I've got 2 good ones that I think here. Can a board operate with an even number? So the composition of your board is typically set forth in your articles of incorporation and your bylaws, or could be either or. Look at your bylaws to see what number your board has to consist of, what number of directors your board has to consist of. If it's something where it can consist of an even number, then yes, your board can operate with an even number. Hopefully, there's not an even split as far as the vote goes. Typically, in those cases, we follow Robert's rules if there's reference to it, and the president has the tie-breaking vote, whatever. But your board usually is required to be an odd number. However, if there's a vacancy, like maybe it's supposed to be a 5-member board, but there's a vacancy there that they haven't filled. Whether or not they have to fill that vacancy, again, look at your governing documents, usually within your bylaws, and it'll say either the board may or the board shall. So it's whether it's mandatory or if it's optional. Because your board is still able to obtain a quorum of the directors, which is usually a majority of the entire board, which a 5-member board would require 3 director attendance at a meeting, the board is still able to conduct business. So long as you have that quorum of the board established, you're not going to be in trouble as far as that 4-member board conducting business for the association. Caveat that being, if it's supposed to be 5 and they must appoint someone to the vacancy, then they need to be appointing someone to that vacancy. But you're not in trouble of being run by a receiver because they're still able to obtain a quorum.
Yeah.
And finally here, does 720 required board meeting to be in person, or is virtual only okay? She knows that 718, which is our Condominium Act, needs at least to be at a place where people can attend in person. And
Right.
yes, you're correct. For 718, this past legislative session, they added a new term called video conference, where a meeting can be held using both voice and video real-time communications, such as Zoom, for a board meeting or membership meeting. However, there does have to be a physical location where owners can actually attend the meeting. This change was not made in Chapter 720. 720 still has no reference to video conferencing for the use of meetings. Now, I know a lot of people, when the pandemic was here, got very used to doing meetings via Zoom only, and may have continued doing Zoom meeting only meetings after the fact. However, that's not what's provided by statute. And the fact that the Florida legislature adopted a law concerning video conference meetings for condominiums and not HOAs, to me, is further indication that HOAs, you can't have Zoom meetings, Zoom only meetings. You're really going to have a hybrid if, there's no other case law out there pertaining to this. Like I said, HOA law in the courts is not developed at all. So until a court says otherwise, I think you could still have hybrid meetings, but certainly not Zoom only.
And so it was best to err on the side of caution anyway, because you have people.
Right.
I mean, look at today. Some folks are confusing the Q&A versus the chat. So, and that's a very simple technology term. So you can't expect everybody to understand the technology. It's always good to have a physical place to go where you set up the tech for them and they can watch the meeting that way.
Right. And especially considering the age of your community,
Right.
look at your demographics and to determine whether or not they're gonna be technologically capable of doing that. So anyway.
Yep. I know that was your last question. You got a couple of appointments to get to before the weekend. I appreciate you so much for filling in and helping Peter out on his getaway. I know he had to get
I
out
know,
quick.
I should have said, have a great trip, bring me back something French.
Yes, New Jersey, right? Bring some good bagels back.
I know, but that's a line from that great American movie classic, Home Alone. Come on.
Home Alone. Yeah. Every Christmas. Watch it
Yeah.
every
Are you
year.
kidding? I have two December babies in my house, my husband and my son. So it's like they watch Christmas movies all the time
That's
because
great.
it just brings them such great personal joy.
There you go. Good stuff. Good stuff. I'm old.
All
I'm
right. Well,
partial
thank you so
to
much. And thank you to Hawkeye. Sorry you guys couldn't join.
yeah.